shown here, see your attendance, and you will be heard. Please be seated. Good afternoon. Welcome to the Appellate Division First Department, and to those of you who are here for the first time this season, welcome back. I am about to call the calendar, so please listen carefully. We have some 6.5 hours of argument time that has been requested, so please bear that in mind as I call the calendar, and only ask for the time that you absolutely need. People versus Artemio Soto Bercheril? And respondent? Okay, I'll give 5 and 2 and 5. Thank you. Jay-Z versus Salerno? Respondent? Okay, do you want to submit or argue against yourself? Or I don't. How about 2 minutes, and if there's any questions, we'll see how that goes. Thank you. 2 and a submission. Francisco A. versus Amaryllis V. And respondent? Do you want to submit? Say that again? I'll give you 2 minutes. Wallace versus Amazon is submitted. Lopez Cedeno versus D.L. Peterson Trust. 8 and 4. And respondent? Okay. 5, 2, and 5. Thank you. People versus Joshua Brignoni. Submitted. Barry Mays versus New York City Health and Hospitals. 6 and 2 and 5. Indec Energy versus Merced Capital. Is the respondent here?
Yes, Your Honor. We request 15 minutes with 2 reserved for rebuttal. We're a cross appellant as well.
You are cross appellants, so I'll do 7 and 2 and 7 and 2. People versus Jameer Sneed. Respondent? 5, 1, and 4. People versus Christopher Rodriguez is submitted. Oustacher versus Clark.
9 and 4.
Respondent?
8 minutes, Your Honor.
I'll give 7 and 2 and 7, and I am recused from that case. 8 Jane Street versus Patron. Respondent? 7 and 2 and 7. Renee B. versus Jeffrey B. Respondent? Do you want to argue? There's no. If you would speak up, please.
I'll take 2 minutes, Your Honor.
Okay, thanks. Linares versus the City of New York is submitted. People versus Ryan Rohan.
Request 6 and 1, Your Honor.
Respondent? 5 and 1 and 5. People versus Troy Buford is submitted. Telemann Holding versus VCW Associates.
Good afternoon, Your Honor. Appellant request 8 and 2.
Your Honor, respondent request
6 and 2 and 6. Kim versus NRT NY.
Your Honor, appellant requests 5 and 1.
5 and 1. And the respondent? I beg your pardon? 5 and 1 and 5. Thank you. People versus Colin Washington. And the respondent? 5, 1 and 5. Thank you. People versus Keith Little. And the respondent? Um, 5, 2 and 5. Stengel versus Vance. 2 actions. They are submitted. First case for argument, People versus Artemio Soto Becerril. You may proceed.
Good afternoon. May it please the court. Henry Ross from Krieger, Kim & Lewin, pro bono counsel in partnership with the Legal Aid Society, on behalf of appellant Artemio Soto Becerril. The trial court's failure to instruct the jury on Mr. Soto's requested agency defense requires reversal of his drug sale conviction. And, in the alternative, the 7-year sentence imposed by Justice Mandelbaum was excessive and should be reduced to the 6-year minimum in the interest of justice.
So with regard to agency, what has to be demonstrated in order to qualify for an agency defense?
Your Honor, the defendant must show that some evidence, however slight, viewed in the light most favorable to the defendant, supports an agency defense. And here, there was clear evidence.
Doesn't there have to be some, what do we base that on? Don't we have to base it on the relationship between the defendant and the buyer, the person who he's claiming to be the agent for?
Yes, Your Honor, but it's important to keep in mind that no prior relationship is required, no relationship of friendship or pity is required for an agency defense. The defendant simply needs to be acting on behalf of the buyer to be considered an agent and to be eligible for the agency defense.
That's true, but here he simply tells him he'll get the drugs for him. I mean, he claims that he denied it at first, but then he says, okay, he'll do it. But what suggests that he's doing this not for his own, because he's selling himself or because he's working for the dealer?
Your Honor, it's the fact that here there was no evidence that the defendant was working for a drug selling operation or that he was working to make an individual profit. That leaves the only plausible inference to be that the defendant was working on behalf of the undercover buyer. Here, there was clear evidence in the record that Mr. Soto was not part of a drug selling operation and was not working to make an independent profit. With respect to the profit factor, substantial evidence showed at trial, and when viewed in the light most favorable to Mr. Soto, indicated that Mr. Soto did not profit from this transaction. It was undisputed at trial that the street value of the drugs in question was $20. And although the undercover officer testified at trial that he gave Mr. Soto 2 $20 bills in 2 separate transactions, there was much stronger evidence that the undercover officer only ever gave Mr. Soto 1 $20 bill. First, in grand jury testimony that was used to impeach the undercover officer at trial, the undercover officer mentioned only 1 $20 bill. And more importantly, at page 128 of the trial transcript, the Detective Ramirez, the arresting officer in this case, testified that he saw only 1 exchange of objects between Mr. Soto.
Can I stop you for a minute? My concern is that if this evidence would satisfy the agency defense, or at least the issue going to the jury, doesn't it require an agency defense in almost every kind of street level drug buy?
It does not, Your Honor, and there are two key distinguishing facts in this case. The first is that Mr. Soto or his friend, Mr. Cruz, initially declined the request for drugs. It is very rare in an undercover buy case for the defendant or for his acquaintance on the street to decline a transaction and change their minds a few seconds later. That is simply not how drug selling operations run. And then the more important...
Why not? I don't understand why you're making this assumption. It's completely speculative. I mean, maybe he looked at the person and thought at first, hey, he looks like an undercover. I'm going to refuse. And then, given his response that he just walked away and didn't persist, maybe he thought, hey, you know, I'll deal with this guy.
Yes, Your Honor, but there's
Why is
nothing
that
in...
out of the realm of possibilities here.
Your Honor, there's nothing in the record that indicates that the defendant or his friend took any steps to verify that this buyer was not an undercover, and there's just simply no evidence in the record as to why they changed their minds. But it's certainly...
Right, so but you're suggesting that we should look at it, you know, in the way that he changed his mind because he was working for the buyer all of a sudden. I don't
Yes, Your
see
Honor.
what there is here that suggests that.
So the initial reluctance is one piece of evidence, and that's actually what the Third Department held in a 2012 case called Money Cook. But the more important distinguishing factor, going back to Your Honor's question, about why requiring an agency defense here would not require an agency defense in every buy and bust case. In the typical case, it will not be onerous for the prosecution to present evidence, conclusive evidence, that the defendant profited from the transaction, and the prosecution entirely failed to do so here.
Counsel, how do you address the fact that $20 of pre-recorded buy money was recovered from the defendant?
Your Honor, if the jury had credited Detective Ramirez's testimony, which we believe it would have, that testimony indicated that the undercover officer gave Mr. Soto the $20 bill mere seconds before he apprehended him. There was no time for Mr. Soto to dispose of that money, and the most plausible inference was that that money would be used to recoup Mr. Soto's cost of obtaining the drugs, the street value of which was $20.
Thank you. Let's hear from you.
Good afternoon, Your Honors, and may it please the court, Molly Morgan on behalf of respondent. As the trial court properly recognized, there was not, quote, anywhere close to a reasonable view of the evidence that defendant obtained drugs for the undercover officer merely as a favor to the officer. Indeed, the undercover officer, who was a total stranger to defendant, was walking away when defendant roped him back into the drug transaction. Of particular importance, there was no reasonable view of the evidence that defendant obtained only $20 in exchange for the heroin. While defendant relies heavily on the undercover officer's testimony before the grand jury that after defendant returned with the heroin, the officer looked at the heroin and walked away, the undercover officer also explicitly testified before the grand jury that he and defendant had arranged for a $40 transaction for the heroin.
Well, at least in the record, because this is just whether the jury should have gotten the issue, there is a plausible look at this that only $20 was actually passed hands, right? That was all that was recovered, $20, and that's what the officer originally said, correct? It's a plausible view of the evidence. The jury did, or the finder of fact didn't find that here, but the issue for us is should there have been an instruction?
Right, yes, absolutely, Your Honor.
So does it matter? Because the amount of money that passed hands was the value of what the heroin is, does that mean that the person that the defendant was arranging the transaction for the buyer?
Well, Your Honor, I think even setting aside profit, there's no other indication of an agency kind of relationship here. And again, what defendant is doing here is exploiting gaps in the people's...
So here's my question. With the $20, which is the street value, doesn't that contemplate profit? I mean, people are not selling heroin because, you know, out of the goodness of their hearts. They're making money on it, right? So $20 street value is a profitable sale, is it not?
Absolutely, Your Honor, and that's the people's position. There was no authority on that point, but it certainly makes sense that people are not out on the street selling heroin at a loss, and that $20, which as the trial court recognized was the street value of the drugs, entailed profit to defendant. So even assuming that he only received $20, that factor does not weigh against, does not support an agency charge. And again, looking at all the factors in
Can
conjunction.
I just get this question in. Is it significant that he rejected it at first? Is that significant at all?
I don't think that's significant at all because that's coupled with the fact that he immediately called him back and the undercover was going to walk away, but for the fact that defendant called him back. And
What about the grand jury testimony? Was there something that the undercover didn't reveal at first or didn't reveal at all, that he that there was this rejection of it at first?
well, yes, the undercover's testimony before the grand jury with regards to the initiation of the transaction did contain a slight variation, but
He said it was the other person instead of this person.
right, but he explained at trial that he didn't mention Cruz before the grand jury because Cruz wasn't under indictment, and we submit that that's
A
That's a-
lie? Is that some sort of, I mean, what, he said something different at the grand jury, and he said it was because he thought that, you know, he thought that it would confuse things for the grand jury to actually know who said it. So he said that someone else said it.
well, yes, Your Honor, that's right, but it's our position that he was simply trying to clarify things, and I don't think that explanation cast doubt on the rest of his testimony. And in any event, under both versions, there was no dispute that it was defendant who called the officer back and affirmatively roped him back into that transaction. Again, the people would be happy to provide the full grand jury minutes under seal if the panel would so request. I think it's also critical to note that had the court granted his request, the people then would have been entitled to present evidence of his prior drug sale conviction, and that prior conviction, coupled with the overwhelming evidence of defendant's guilt in this case, would render any error harmless.
Thank you.
Unless the panel has further questions, I'll request that you affirm. Thank you.
Thank you.
Your Honors, opposing counsel incorrectly argues that two principal facts defeated an agency defense here. First, the undercover's trial testimony that two $20 bills were exchanged. And second, the fact that the defendant and the undercover officer were strangers to each other prior to this transaction.
Well, I asked her a question about, let's assume for a moment only one $20 bill was passed, because I think that's a reasonable view of the evidence, not necessarily the view that was accepted by the fact finder, but certainly a view of the evidence. Doesn't matter. Isn't there profit in selling heroin on the street for $20?
No, Your Honor. Multiple witnesses testified here that $20 was the street value of the drugs.
But he sold it on the street.
But there was no evidence that Mr. Soto was able to receive those drugs at a discount or for free.
Well, why do they have to do that? He was the one who he got the $20, and then he went and got the drugs, we don't know from where, and then he gave the drugs over. So I'm really not following this strain of argument.
The important
It's
point,
a profitable sale.
Your Honor, the prosecution is not entitled to the presumption that no matter how much cash a defendant receives for drugs, that cash inherently or necessarily constitutes a profit.
I didn't say it was a presumption. Who said it was a presumption?
If the people are unable
Isn't
to...
it a reasonable inference? Street value, $20. It's sold on the street.
It would be a
He
reasonable...
wasn't, we don't know what he did with the $20, quite frankly.
That's right, Your Honor. And when the people are unable to show conclusively that the defendant received more than the street value of the drugs in exchange for those drugs...
So in other words, then I'm going to get back to my original question to you. Doesn't your argument mean in almost every street transaction, because it's common that somebody who's selling drugs on the street then goes back to someplace to get the drugs, that then they come back with them after getting the money or the money exchanges afterwards, that an agency defense would be required under your view of the law?
In the ordinary case, Your Honor, it will not be a heavy burden for the prosecution to present evidence of profit. The undercover officer can keep track of the buy money involved or of the serial number of the buy money, can record audio or visual recordings of the transaction, or can simply provide uncontroverted evidence of profit. None of those things happened in this case, and an agency defense therefore should have been given. May I very briefly address the sentencing point, Your Honor?
I don't think we need it. Thank you
Okay.
very much.
Thank you very much.
Thank you both. Jay's, oh, I'm sorry, you were with a law firm?
Yes, Krieger, Kim, and Lewin, Your Honor.
We thank you very much for volunteering to do this, and thank your law firm for letting you do it.
I will. Thank you.
Appreciate it. Thank you. Thank you both. Jay-Z, an infant against Salerno.
Good afternoon. May it please the court. My name is Louis T. Kronaki III, from Hagel and Spencer, attorney for the appellants. The lower court got this wrong. The respondent is negligent per se for violating 4 vehicle and traffic laws by crossing where it wasn't safe to do so.
Counsel, there's a conflict here in the two versions, so why isn't there an issue of fact?
Well,
There's nothing that in the record that says that the way your client says it happened is the way it happened.
well, the impact was not to the front of my client's vehicle, it was to the passenger side.
Okay, but those are facts, that's a question. Now, you're saying because it happened this way, it couldn't have happened this way. There's still another person who's plaintiff says it happened a different way.
But if he steps out 2 feet from between 2 parked cars, the accident doesn't happen.
Is that actually that clear in the deposition? I read the deposition, and it seemed like what he was talking about, or responding yes to, could have been that he was standing in the parking lane, right? I mean, that was what came before him, and then there's a question about parked cars, and he's like, yes, the parking lane. So at least to me, when I read it, it wasn't exactly clear to me that there was an admission that he was coming out between parked cars.
Well, most importantly, the responding police officer who prepared the report was produced for a deposition. And he found that the respondent was crossing not with a crosswalk, and most
But
importantly,
he
cited
didn't
him for
witness
fault.
the accident.
Yes, but it's under an obligation to prepare a police accident report in accordance with the rules of the city. And most importantly, he did not give a Vision Zero ticket. And Vision Zero is initiated by the city where anytime there's an accident involving a pedestrian or a bicyclist, the officer has to give a ticket unless it's blatantly obvious that there's no fault. So at the very least, the appellant should be entitled to an inference of negligence, and the apportionment of liability should be left to the jury to determine, if any.
Thank you.
Thank you.
Francisco against Amaryllis.
May it please the court, Bruce Young for the appellant, Amaryllis V., the mother of 2 teenage children, which were seeking to modify the custody order that she had retained for most of their childhood and remand for a better visitation schedule, and to vacate the family offense petition. I think there was a significant stigma that was improperly used by the court, not properly regarding the history of domestic violence where my client had been the victim that got turned around on her without really having a full opportunity to be heard. Most essentially was the failure. Prior notice was given of a material witness who would have corroborated the disputed evidence at the incident where there was an exchange. She came back after being taking care of her ill father. Supposed to be a week. It took
The court here listened to a lot of testimony and said that it felt that it understood the issue and that it had enough testimony on it. It had satisfactory, sufficient testimony in a particular issue. And the court, under all circumstances, taking all circumstances into consideration, gets to control the schedule and make those determinations. And seem to, based on the record as I read it, to have considered every factor and made some determinations about credibility here.
I don't think it's clear that the court actually had awareness of the history of domestic violence against her that was established, fully adjudicated. He just says, I've considered domestic violence. He had a
Yeah.
family offense case in front of him, but he wouldn't permit the record to be expanded, both on
Well, there
her
were two things about the history. First of all, the additional witness was only offered for the sole purpose of the order of protection hearing, right? She wasn't going to testify generally about the history of violence between these parties as a corroborating witness. That was my understanding of the record.
To clarify, the notice specifically said to discuss the issues that occurred on that date.
On that date, right.
And so on that date,
Right.
she came back and saw the
Yeah,
kids
so we're
drinking in
agreed.
front of
We're
them.
agreed. I'm only rushing you because I see your
No,
red light is on.
I'm not.
So my second issue really had to do with the fact that the mother said, gee, there are prior orders of protection that have been issued in this case.
Right.
And it seemed that the court started to look for them in the court file and could not find them.
Correct.
The attorney for the mother never presented certified copies or not. I mean, had they been presented, the court could have considered them, but they didn't seem to be in the record. Isn't that a problem?
That is a problem, but for all the technical glitches and the irritation and the move on. There was constantly a discussion of move on, so
well,
to
isn't
stop.
that a
He
consequence?
wasn't given another day. He wasn't given
Yeah.
another minute. He had a witness and given
That's
notice.
a consequence of the court controlling their courtroom, particularly in light of the pressures on all of us, look at us now, for COVID-19 and unfortunate circumstances.
Right.
But did it deprive the mother of due process is really the core issue here. My question, yeah.
Well, I think the culmination of all of the glitches, technical, the failure to allow a witness to be called that could have been the only corroborating witness, the fact that even the judge acknowledged it's hard to assess credibility in these virtual trials. The judge wrote an article in the Law Journal. I put a reference to it in the brief, about how it's absent. We're not seeing the expressions that we normally would have seen. The culmination of all of those things, curtailing her direct examination, particularly not allowing that other witness to be called, that would have been a corroborating witness when it was just a he said, she said circumstance that would have turned it into something else.
Thank you.
Thank you very much.
Lopez Cedeno versus D.L. Peterson Trust.
Good afternoon, Your Honors. Deanna Hazen on behalf of the defendant, Francesco Nunez. We're here
Counsel, what evidence do you have of any negligence on the part of the plaintiff and the stop here?
Your Honor, the issue is not whether there's any evidence. The issue is whether or not defendant's given an opportunity at this point. You have two conflicting statements in
This is a rear-end collision.
Yes, it's a rear-end collision.
Excuse me. This is a rear-end collision where there's no statement of any emergency issue. There's traffic where your client skids on wet ground and hits the person in the rear. And I don't see, in my reading, anything other than speculation about what this reasoning about the plaintiff's actions. What evidence is there of the plaintiff's, what caused the plaintiff to stop other than the red light?
Well, Your Honor, no depositions were taken at this time of this motion. There was no discovery. If you look at the police report, which is relied upon by the plaintiff, in her affidavit, she actually says, I agree that the police report is accurate. If you look at one of the factors, I believe it's 19 and 21, which relate to the plaintiff, the police officer does find contributory factors to the plaintiff. It's not marked blank. There's something there that the police officer thought there was some contributory factor by the plaintiff. We had no depositions. It's an affirmative defense that was stricken based upon,
So the police officer wasn't there, so that, the report is hearsay. Obviously, it says nothing about who made the statement, so it's not, doesn't move your argument either way.
but Your Honor, we're not entitled to even question the police officer who told them what, whether the plaintiff told them something. By striking the affirmative defense, we're
There's no
not
evidence
allowed
that
to.
the plaintiff said anything. There's no evidence that that statement even came from the plaintiff.
But that's the point of the affirmative defense, Your Honor. It's a pleading. It should be given the benefit of the doubt to the defendant. If there are questions of fact in the papers, which there are, there's an affidavit of the plaintiff that said, I did not stop abruptly. There's the defendant saying she did stop suddenly. And then you look at the police report where plaintiff says she believes it's accurate. There's an indication there in numbers 19 and 21, I believe, where it says the police officers found a contributory factor of the plaintiff. So at this juncture, where there's no depositions that have been taken, where no discovery has gone forward, a motion for summary judgment with respect to the defendant's liability is different from determining whether or not there's comparative fault. Rodriguez made it clear. A defendant can be found liable, and there's still issues of whether a defendant can prove comparative fault. Because
And I mean, while that's true, of course, we're familiar with Rodriguez, doesn't there have to be something in this record to show that there could be a reason to even find comparative negligence? There was nothing in the record that reflected anything that the plaintiff did that contributed to the happening of the accident. The plaintiff stopped, and the defendant admitted rear-ending her.
the defendant attests that she stopped suddenly. So it's a question of fact, and since there's a question of fact.
Does the defendant challenge that the light was turning red, or that it turned red? Does the defendant challenge that? I didn't see that anywhere.
It's not
The
in
light turns red, and the person in front of him stops. And he says it's a sudden stop. Well, sometimes if you're close to the light, it's a sudden stop, but it's a stop that everybody behind you should be aware of if they're paying attention. What evidence suggests that that is negligent?
But that's the point of the affirmative defense. We should be given an opportunity to develop and prove the affirmative defense whether or not she did something. And by dismissing the affirmative defense.
He was there. What did he see?
He said she stopped suddenly. She said she didn't. It's a question of fact. That is evidence. His statement versus her statement, and she attesting to the accuracy of the police officer's, the police report, creates a question of fact, which
Thank you.
should allow us the opportunity. And we ask that the court reverse
Thank you.
dismissal.
Good afternoon, and may it please the court. My name is Marielle Crippen with Burns and Harris for the plaintiff respondent. The motion court properly dismissed defendant's affirmative defense of comparative negligence in this hit in
So
the...
counsel says there's no discovery here. There's nothing. Why should his affirmative defense be decided without the opportunity to have a hearing or do some discovery?
Well, plaintiff submitted an affidavit as to her account of events. The things that defendant does not challenge in his affidavit in opposition, and he does have personal knowledge of the circumstances surrounding this collision. He was there. If there was any evidence of any contributory negligence on the part of plaintiff for the operation of her vehicle ahead, it should have been laid bare.
Well, what about the defendant says that your client stopped abruptly? So wouldn't that be some type of comparative negligence that, notwithstanding that she said, no, there wasn't anything in her affidavit, that he should at least have the opportunity to depose the plaintiff first?
The plaintiff stated that there was heavy traffic on the Henry Hudson Parkway. The defendant does not dispute that there was heavy traffic. The vehicle ahead of her stopped with normal traffic conditions, and there was a red light ahead. That sudden stop alone, and the precedent is clear, that is not enough to raise a question both as to defendant's negligent operation and comparative fault on the part of the plaintiff. There is simply no evidence here. It's wildly speculative to think that a deposition would reveal anything. And I will note that their appeal does reference needing discovery. And although this appeal was filed in May, the deposition of plaintiff was held in January. Since then, 8 months later, there's been no motion to renew based on any new facts discovered therein. The plaintiff did not contribute to the happening of this accident. A driver has a duty to anticipate things like sudden traffic stops, especially on a busy highway at 8:50 in the morning on the Henry Hudson Parkway in Manhattan. There's simply no evidence here to warrant overturning the lower court's decision on these facts. The defendant also states in his affidavit he was traveling 30 miles per hour, and he had just changed lanes prior to the incident, and that's how he struck the vehicle in the rear. If anything, his affidavit just shows more evidence of negligence and further forecloses the possibility of any contributory negligence on the part of plaintiff, the lead vehicle.
Thank you.
If the court has no further questions, I can rest on the brief.
Thank you.
Very briefly, Your Honor, Your Honors, the issue isn't the defendant's negligence in this case. That's been determined, and Rodriguez makes it clear that there's a distinction between the defendant's negligence and whether or not plaintiff may have done something. She also attests in her affidavit that I was struck immediately after coming to a stop. It goes in and she stopped. It goes in conjunction with she stopped suddenly, which was attested to by the defendant. What's at issue here is that prematurely, the trial court dismissed an affirmative defense, not allowing defendant an opportunity to develop it, to get proof on it, which goes to the diminution of damages and can also have an effect on the calculation of interest later down the road. And we're being precluded completely by a decision based on an affidavit and its trial by affidavit where we have no control and have not had an opportunity to speak or question the plaintiff.
The interest doesn't enter into it. You've just admitted that you're not contesting your client's negligence. That under Rodriguez would trigger liability, doesn't that? So that's not the consideration here. The issue is, and I think we have jurisprudence on this, that a stopping suddenly by the vehicle in front is not actionable. It doesn't make your client's conduct non-negligent, nor would it obviously amount to negligence on the part of the plaintiff. So the question really is, did you have anything to otherwise warrant discovery here? And I'm not sure that we're seeing it.
My reading of the law is that the sudden stop does not create a non-negligent explanation for the defendant's liability. And under Rodriguez, we have the right to develop whether or not plaintiff may have done something, especially where the police report indicates some contributory factors were assessed to the plaintiff and it was not marked blank. And we ask that the decision be reversed as to the affirmative defense. Thank you.
Thank you. Barry Mays versus New York City Health and Hospitals.
Good afternoon, Your Honors. My name is Andrew Rosinski. I'm with the law firm of Eisenberg and Baum, and I represent the appellant in this matter. Under the New York City Administrative Code, all accommodations are reasonable, where, as here, there is no undue hardship. Defendants have conceded that providing an interpreter to Andre Barry is not an undue hardship. And the record, as laid out in the brief, demonstrates over and over again that Mr. Berry was not afforded communication in his primary language, and there were numerous consent forms and procedures that were conducted, which under the Patient's Bill of Rights are rights that are afforded to have a full participation and a full understanding of his medical care, and he was denied that. Now, they rely on some instances where they say, oh, we wrote notes with him, or we had him read lips, but the evidence contained in the record, in the own medical records, say that that is a disputed issues of fact as to whether he was fully understanding. And in fact, there were many times noted in the records in which staff said that they could not communicate with him without the usage of a sign language interpreter. We have noted many instances in the record in which Mr. Berry was not afforded the rights and privileges that are protected by the New York City human rights law. And under all of the case law that we provided to this court, the two cases that the trial court...
Counsel, was there any evidence in the record that the decedent actually asked for an interpreter at any particular time, was specifically denied either an interpreter or some accommodation at that time?
So there are indications that the staff had recognized that he required an interpreter, yet failed to provide them, despite them being readily available. They had these machines called video remote interpreting machines that allowed them within a few minutes to bring in a remote interpreter at any point in time. This was easily accessible to them.
And they did frequently provide either an interpreter or the use of that machine, didn't they?
They did not. It was actually infrequent. If you look, and we tried to lay out in the briefs, charts showing the times that they provided interpreters and the times that they didn't. And if you look at it, you will see that for a majority of his medical communications, he was actually not provided a sign language interpreter, despite the fact that they knew that he was deaf. There are entries in there that they know that he had extreme trouble communicating without the use of a sign language interpreter.
But didn't he specifically indicate on occasion that he wanted to read lips and didn't want the interpreter?
So there is an entry that says that he wanted to read lips, but the person who wrote that statement in couldn't explain as to how he determined that preference, because it's a disputed issue of fact as to whether he could actually communicate clearly at all through other means via his English abilities.
Was that really disputed? I mean, his relatives who were bringing this action on his behalf indicated that was how they communicated with him.
They said that communicating with him was actually very difficult.
I mean, I think his mother and his sister even testified or put in some evidence that they never learned sign language,
right,
so that they had to communicate with him that way throughout his life.
Correct. So they said that that's how they communicated with him, but they said that communication was very limited and was very difficult to communicate him through that manner. So, for instance, if a Spanish-speaking patient goes into any of the health and hospital court facilities, they are affirmatively offered an interpreter. They have a right to communicate in their primary language, and deaf people have the same...
What happens if a person refuses the interpreter? Is there something actionable then?
So
obviously... I'm raising it as a hypothetical.
Sure.
I understand you say that's not this record.
Right. So, if someone absolutely refuses all accommodations that are offered to them, there would be no liability under the New York
Well, no, we're not talking about absolutely.
Yes.
They refuse the sign interpreter.
Okay. So there
In favor
are...
of something else.
Right. So in this case, and there's a policy that they have to document all refusals from the patient, and that's required among their hospital staff. In all of these substantial number of visits, there are only 2 instances where they documented a refusal. And on one of the instances, a refusal was documented, but then the social worker came back with a supervisor, and they utilized a sign language interpreter during that time.
Counselor, if I may, can you address what issue of fact the plaintiff raised with the decedent's inability to effectively communicate with his providers, particularly since the decedent could read lips, he refused an interpreter and, was able to communicate by writing notes. So what was the issue of fact raised as to his inability to effectively communicate with his providers?
Sure. So there is no evidence that the respondents can point to say that he effectively communicated medical treatment or medical communications via lip reading or via English. In fact, if you look at pages 9 through 13, 14, 15 in our brief, you will see quite a number of instances where it says interpreter is required for Mr. Berry, that they have an inability, he has a difficulty and inability to speak, an inability to communicate, and that he usually requires sign language help. And Health and Hospital Corp does not actually dispute that he should have been offered an interpreter, he should have been provided an interpreter. They've taken this position with the U.S. Department of Justice, in which they send letters to them during notice and comment periods where they say that deaf people have an absolute right to communicate in their primary language. And where the discrimination is even assuming he has some ability to communicate via lip reading and note writing, which is very disputed, and we lay it out very clearly in the brief, his primary language is American Sign Language. And for instance, if they required...
If you just wrap it up, because you have rebuttal, so just finish your thought here.
Okay. If they required someone of a protected class to only write notes with their doctors and they were not allowed to speak, even though they were able to write notes back and forth and they may be very educated and be able to communicate back and forth, they're treated differently because they're not allowed to communicate in their primary language based on their disability. And so here, clearly he was not able to communicate in his primary language, and there are quite a number of disputed issues of facts that would preclude summary judgment here. Thank you.
May it please the Court, Claude Platten on behalf of New York City Health and Hospitals. The Court may affirm the grant of summary judgment for H&H on either of 2 grounds. First, because at all points Mr. Berry was able to communicate effectively with his providers about his treatment. And second, because there's no relief that this Court could grant.
There are some instances where he does not have an interpreter, I think when there's a consent form. There's no interpreter, there's no evidence that he said it was okay.
Well, no, Your Honor.
Instances? Maybe I'm...
Oh, okay, sorry.
No, maybe I'm misstating it, but...
No, there are some consent forms that don't have an interpreter's signature, but in each case, there's 2 different categories, I guess. There are consent forms where there's clear evidence that he met with an interpreter prior to signing that form.
Yes, not those.
And explained, and the procedure was explained to him. It just wasn't at the time this form was signed. There are many consent forms that are general consents to treatment when he arrived at the hospital before he was being treated, where they weren't explaining the risks and benefits of any procedure yet, and we have to put those in a different category.
Wait, but did those have an interpreter? Those that you want to put in a different category, the ones you just...
Not necessarily, but they weren't explaining the risks and benefits of treatment yet for those.
If there's anything, any kind of consent at all, shouldn't he have an interpreter? And why would that be okay for him not to?
Right, because, Your Honor, well, there is no dispute of fact that Mr. Berry could communicate with lip reading and voicing. There are numerous indications...
Wouldn't it be important to indicate, if that was the case, each and every time he refuses interpreter? I mean, the idea is he's supposed to always have an interpreter or some device that can interpret unless he chooses, opts not to. So if you're saying he's opting not to, shouldn't that be recorded in some way?
Your Honor, the goal of the burden under the city human rights law, the obligation is to ensure that Mr. Berry was able to effectively communicate in every situation with his providers. And that is a context-specific inquiry. There are many situations where it's a complex medical decision being explained to him. He had an interpreter for those. He was able to speak with his doctors. He was able to speak with the social workers about his discharge plans. And then there are many interactions where they were speaking with him about different kinds of, they were checking in on him, they were assessing his vital signs. He was in the hospital for a week to 2 different occasions. And they meticulously documented his ability to communicate, the fact that he was engaging, that he was asking questions, that he was, that they have quotes in the record about his statements. He was making himself understood. We rely on clinicians and doctors and nurses all the time to make judgments about whether their patients are understanding and being understood. And this is exactly what they were doing. They were meticulously attending to his disability. They knew he was disabled. They were recording his communication ability. And when they thought he needed an interpreter, they brought one in. He had an interpreter almost every day at Jacobi. He had an interpreter every day at Lincoln when he was hospitalized there. There were some instances where he came into the emergency room for dialysis at Lincoln Hospital. He had had dialysis 3 times a week for a year or years. He knew what dialysis was. He was able to tell them, I missed my appointment, I need dialysis. If they made a judgment there that he hadn't asked for an interpreter and they understood what he needed, then they went ahead and provided him with care without the interpreter. If he'd asked, there's not a single instance in which he asked and was denied an interpreter. There's been extensive evidence that he was able to communicate at the times when he didn't have one. And there's no evidence in this record of a time when he did not understand. And the fact that some of his providers at times indicated that they thought he needed an interpreter, well, it can mean several things. It can mean that they were trying to communicate something complex to him, and then they went and got an interpreter at some point later and did have that conversation. It could mean that they weren't as good at understanding him, or but the point is, there's no evidence documented here, and that's all the evidence we have, that at any point he was not able to have a meeting of the minds of his providers to understand what was going on. He knew interpreters were available because they were provided to him many, many times, and if he had ever felt that he didn't understand, he could have indicated because he had the ability to communicate. This isn't an individual who could only communicate via sign language. I acknowledge that that would be a different case. This is a person who was engaging with his providers, and they assessed his ability to communicate. Sometimes they thought he needed an interpreter, and other times they believed that they could proceed. And the human rights law requires an accommodation be effective. It doesn't require a sign language interpreter every time. I see my time is up. If I could briefly touch on the issue of damages, because I think it's a more straightforward way to resolve this case. Ms. Berry Mays waived any claim for compensatory damages by not arguing it in opposition to summary judgment. There is no evidence that Mr. Berry ever suffered emotional distress, so even if it hadn't been waived, there's just no compensatory damages on this record. There's no nominal damages available because Ms. Berry Mays waived it by not raising it in her opening brief. And this argument about statutory damages, damages just for the fact that the city human rights law was violated, there's no basis in the statute for that. The provision that they rely on is about standing. It's not about damages.
Thank you.
Thank you, Your Honor.
So in pages 5 through 8 of our brief, we clearly, in our reply brief, we clearly demonstrate to the court all the times in which respondent had failed to respond for times where clearly effective communication did not happen. And for them to say that he lip-read and understood everything in the record is misleading because all the facts demonstrate that he had extreme trouble communicating via lip reading and via written English, and therefore could not communicate without a sign language interpreter. These sweeping statements that he was provided effective communication at every turn is simply just not true, given the record of their own staff here. And moving on to, and their own legal enforcement guidance even states that that under the New York City human rights law, hospitals must provide a qualified sign language interpreter to a patient who is deaf as a reasonable accommodation, because in order for a patient in a hospital to enjoy the right or rights in questions, they require in-depth, time-sensitive, and nuanced communications with medical personnel.
Counsel, was there any evidence in the record that anyone on behalf of the decedent's family members that seemed to be visiting him ever filed any complaint about this situation, so that there was any, I'm not saying there had to be, but was there any proof, anything in the record that showed that?
Yes, Denise Berry actually complained that his brother was not getting interpreters and that he required interpreters to be able to communicate with staff. And those instances are indicated in our brief, in which we demonstrate that she did make phone calls, she did make complaints in person. There is no formal written grievance that she made, but she complained to various medical staff in the record there.
But didn't she also testify that the decedent read her lips, and that's how they communicated, since she could not speak sign language?
So there is that, but there's also, as we indicate in our brief, on page 3, it says, Denise Berry testified that Andre Berry knew American Sign Language and could use it with his friends. She further testified he couldn't read and spell that well, so her written communications to him were limited because she knew he wouldn't be able to read it. And she also stated Andre Berry would only be able to understand some lip reading, and that is only when he is paying attention and the speaker takes time to enunciate. And she recalled that she would have a hard time to get him to understand what she was saying through lip reading. So that was a testimony. This is a disputed issue of fact that should be resolved by a fact finder as to what his communication abilities were and whether he should have had a sign language interpreter for all these interactions, which their own legal enforcement guidance say that they must provide to deaf patients. And that's why this should be remanded, reversed, and decided by the fact finder.
Thank you.
Okay.
Indec Energy versus Merced Capital. Merced Capital.
May it please the court, David Ellsberg from Selendi and Gay for defendant appellant Merced. I'll address the breach of contract ruling by the lower court, which is erroneous, but I want to start with the lost profits ruling, because the lost profits ruling contradicts decades of New York precedent, including the New York Court of Appeals.
I'm just going to ask that you put your mask up, please. Thank you.
Yes, Your Honor. It contradicts decades of New York precedent, including the New York Court of Appeals decision in Kenford and Ashland and Goodstein versus New York, and this court's decision in RXR2, which involved the very same language in a confidentiality agreement, which is present here. New York law has been clear for decades, Your Honor, that in order to get lost profits, the parties must contemplate lost profits at the time of contracting. On summary judgment here, the only evidence of what the parties contemplated was the contract itself. And the contract itself here said nothing about lost profits. On summary judgment, that alone created an issue of fact for trial, because Kenford says that if a contract is silent, that suggests the parties did not contemplate lost profits. And there are additional fatal flaws in the lost profits summary judgment ruling. In RXR2, this court, the First Department, held that the very same language here suggested that the parties did not intend lost profits. Specifically, in RXR2 and in this confidentiality agreement, they both say that, number one.
Can I ask you, what did the contract contemplate in the event that the confidentiality agreement was violated?
So
what were the remedies?
Yes, Your Honor. So the typical remedies for breach of a confidentiality agreement are compensatory damages. So for example, the complaint here actually sought compensatory damages for the amount it cost for INDEC to create some of the studies. They sought $71,000. And they also sought the amount of money it cost to recruit and hire replacements and the increase in salary. And so there are remedies available, but the point here is that they can't get lost profits because the contract here in RXR both said, number one, the parties had absolutely no obligation whatsoever to enter into any transaction. A reasonable person wouldn't expect they're going to end up for lost profits as if they had entered into a definitive transaction and breached it.
I know the Supreme Court concluded in its decision that the whole point of the confidentiality agreement was to prevent your client from stealing the plaintiff's employees and confidential information so that the plaintiff would not lose its ability to be the first mover on the project, which is kind of the whole point here. And this was very confidential information, which is why businesses, and specifically these sophisticated businesses, entered into a confidentiality agreement, because once somebody else becomes the first mover, you'll lose a lot. That had to be anticipated. To say that wasn't in anybody's mind is kind of far-fetched.
I don't think so, Your Honor. What that means is that the parties anticipated that there would be a remedy. But as Your Honor says, that is, Your Honor just acknowledged that the point of confidentiality agreements is always what you just described. So if allowed to stand, this case would turn lost profits into the rule rather than the exception. And I'd also note that the confidentiality agreement—
Probably not, though, because I think if, in fact, this case is allowed to stand, that lawyers would then be more meticulous about whether they contemplated and put it in expressly or not, what the remedies are for confidentiality agreements. So I have more faith in the legal profession than you do.
Your Honor, a holding like that would be directly contradictory to Kenford. And what Kenford says and Ashland says and Goodstein says, all from the New York Court of Appeals, is that where silence means you did not intend it.
What I don't agree is that there are dire consequences from whatever we decide to do here. I don't think so.
Whether or not you believe there would be dire consequences, it would be directly contradictory to Kenford, which says parties do not need to be scrupulous in putting in language disavowing lost profits. If the parties do not mention lost profits under Kenford, that is an indication that they did not intend for lost profits. And here—
Yeah, the other remedies that you mentioned, they're not in the contract as well, though, right?
Exactly, but the rule for compensatory damages is completely different than lost profits, which is an extraordinary remedy. And when there is silence under Kenford, that alone is an indication that the parties did not intend it. And
So
this
it
was a
doesn't say—
summary judgment ruling.
Your claim is that as a matter of law, they always have to be expressly provided. They can't be implied from the contract?
No, Your
Yeah,
Honor.
they
I'm
can
saying,
be. Right.
I'm saying that here there's the same type of silence as there was in Kenford and the same type of affirmative language disavowing lost profits that was in RXR2. And on top of that, Your Honor—
Well, in RXR2, isn't there language about for matters specifically agreed to herein?
Yes, and that was important language.
And so for here, isn't it kind of broad? Doesn't it say fundamental for the protection of each party's legitimate business and proprietary interests? And then it also says all other remedies available at law or in equity?
Your Honor—
So isn't that rather broad? Wouldn't that include this the
No.
way that it did in RHR?
No, RXR included the same language.
RXR, rather?
RXR2 included language that said the obligations will only be what's set forth herein, and it include the other two clauses that I mentioned. And all confidentiality agreements have the language that say the purpose is to protect the confidential information. It would turn lost profits into the rule.
The case, the Court of Appeals case that you've been referring to so strongly, say that when determining whether lost profits were actually in the contemplation of the parties, the courts first do look to the contract, of course. And I think I'm quoting from that case, in the absence of such a provision, then the parties consider what the parties would have concluded had they considered the subject.
Yes, and given the silence under Kenford, that is evidence. Silence is evidence the parties did not intend lost profits under Kenford. And on summary,
I don't think that's what it says, but.
I think, well, Your Honor, it also includes the other provisions that I mentioned. And also what Kenford said is that lost profits cannot be speculative. And what the court did here was pile assumption upon assumption, including, number one, that the parties would enter into a definitive agreement that they never did, that hypothetical agreement would provide for INDEC to get a split of profits as against the other hypothetical investors, that hypothetically the market conditions, the competition in the market, and all other factors would allow them to make a certain amount of profit over 2 years, that after 2 years a hypothetical buyer would come along and buy the plant for 9 times EBITDA. All of that type of speculation is exactly what Kenford forbids. And so that's another reason that the lost profits award should have been reversed. And again, if this court were to hold that silence does not create an issue of fact in a confidentiality agreement, it will turn lost profits into the rule, not the exception. It will completely defy Kenford, which says that silence is evidence that you do not intend it. This was on summary judgment.
Thank you.
Thank you, Your Honor.
Good afternoon. May it please the court, I'm Steve Molo and I represent INDEC Energy. I guess the first point to raise concerning this lost profits argument is that it is a fact argument that was not raised below, and therefore it's clearly waived under U.S. Bank versus DLJ Mortgage 146 AD 3rd 603 decision of this court in 2019. So to stand up here and take the entire time to argue about lost profits, I think was a huge waste of time because this argument was waived. Secondly, as the court noted, as Your Honor noted, the agreement in paragraph 8 specifically authorizes, in addition to equitable remedies, all other remedies available at law. That's a quote, which would include lost profits. Now, in deciding whether a contract contemplates lost profits, New York courts consider the nature and purpose and the particular circumstances of the contract. And as was noted, in this particular contract, the parties were disclosing, pursuant to the protections that were supposed to be there, highly confidential, highly technical, proprietary information that INDEC, which has a history as one of the premier developers of electric power plants in the United States, was disclosing to people who had absolutely no experience in that area. Merced is a private equity fund based in Minneapolis, Minnesota, that wasn't in this business. The only way they got into the business was by stealing INDEC information.
And it's 2 vice presidents along the way, too, right?
Correct.
Alstrom and what I forgot their names right now, but yes.
And so the contract was designed to protect these very types of harms. And it states that in its terms that these protections are, quote, fundamental for the protection of each party's legitimate business and proprietary interests. And it recognized that a breach, as occurred here, stealing INDEC employees or confidential information, would imperil its ability to operate and to have that first mover advantage. It's clear that was the whole point of this. This was exceedingly important to be the first mover there. And to show you how important it was, that after Merced stole that advantage from us by taking the employees and information and putting it to its own personal use, they bragged about it in marketing materials, saying that we now have the first mover advantage. Again, given the nature of this market, given the nature of the information, it's clear that that's what the agreement was intended protect, and the court credited testimony from several experts and the parties that ERCOT, that agreements in ERCOT would use confidentiality agreements for the express purpose as they were used here.
So in terms of whether or not the lost profits, if we find those are appropriate, were speculative, apparently they never really entered into the agreement. I think it's your party's claim that they kind of that defendants kind of dragged their feet while the litigations were going on, not to enter into an agreement, and they never really got the great benefit of being the first movers that they were hoping for.
Correct.
So does that mean that ultimately the damages that your expert testified about were really speculative?
It was not speculative at all, because these power plants and these projects, they're really projects, right? They have a value at each stage along the way. So early on, someone has the idea, maybe there's some preliminary work done, it's got a particular value. You get a little bit further in the development where there's permitting that's occurred and other steps have been taken, they've got a different value. And the ultimate value that was arrived at here was around $15 million, and then there was interest and fees, attorney's fees. But the ultimate value of this, once it was built, would have been much, much more than that. It would have been over $150 million. And so the discounted cash flow analysis that was done by Cubo, our expert, accounts for that. And that's what took the value down to where it was. It was not at all speculative. Cubo, by the way, was an industry participant. He wasn't just a number cruncher. He had invested his own money, up to $800 million, he said, over time. And the court listened to that testimony. It listened to the testimony of two experts that the other side put on and credited Cubo's testimony and found that it was not at all speculative. One other key point, his projections and his analysis was based upon actual documents and analysis that was done by Merced. So if anything, it was conservative. And this court and the Court of Appeals has highly credited testimony of an expert when it's based upon the projections, the analysis, the documentation of the other side. So it was far from speculative. The conduct was terrible. The court should have allowed us to proceed on our tort claims.
Okay, that's you got right to what I wanted to ask. I have two questions before your time runs out about the tort claims. I know that they were all dismissed as duplicative by Judge Kornreich a few years ago before he ever went to trial. So my two questions are, would the sort of the ultimate question, would there have been any additional damages that would have been available to you had the tort claims stayed in as opposed to being dismissed? And it seems to me that there's some confusion as to whether Illinois law or New York law controlled the different tort claims. And I was wondering if you could address those two things.
So there's two claims. There's the trade secret claim, which is under New York law, and the aiding and abetting a breach of fiduciary duty, which was under Illinois law. Now, there was some...
Why was that?
Under Illinois law, because the conduct occurred in Illinois, and under choice of law principles, Illinois would have the greatest interest in controlling the conduct. Therefore, Illinois law would apply. And there was actually a finding of a breach of fiduciary duty in Illinois. There were parallel proceedings in Illinois against different parties that were related here. And so under both the New York trade secrets law and under Illinois law, tort law, breach of aiding and abetting breach of fiduciary duty, we would be entitled to punitive damages. And that was no illusory right here, because the conduct that was engaged in it was found by both judges, both Justice Kornreich and Justice Schechter found that the conduct was extraordinary. They found that the defendant stole a lucrative business opportunity. That's a quote from the opinion, called the conduct brazen, called their witness, Brogue, who was the mastermind and the head honcho of Merced, quote, disingenuous, untrustworthy, quote, materially incredible. They found that they tried to suppress the value and deceive the court to limit their exposure. They withheld documents that were called for in discovery, thousands of pages of documents, and they signed an agreement to work with Dahlstrom and DePodesta while they were index employees. So if ever there was a case that cried out for punitive damages, this is such a case. And unfortunately, the court got it wrong when it held that the claims for aiding and abetting breach of fiduciary duty and violation of the trade secrets law were duplicative, because they weren't, because we could not get the punitive damages under our contract claim. If there are no further questions, thank you.
Your Honors, we did not waive the argument. Our reply brief at 21 to 22 cites the record evidence, including record page 2382. The fact that parties to a confidentiality agreement, their purpose is to protect information, and the fact that parties to an agreement may intend to make profits, that is the rule. That is the run-of-the-mill confidentiality agreement and the run-of-the-mill contract to do a project together. If that is enough to say that parties anticipated lost profits, it becomes the rule instead of the extraordinary remedy that it's supposed to be. Also, we just heard from counsel that Merced had no experience whatsoever, didn't know what the heck they were doing. That, again, just shows you how speculative this award is. New York courts routinely say when there are months of a track record of profits, that is insufficient to prove lost profits with reasonable certainty. Here, Merced never agreed to go into any business. There never was any business. There was never a single day of any profits whatsoever. And it doesn't matter if the expert, Mr. Kubo here, was supposedly wonderful. In Kenford, the Court of Appeals said, this is the best any expert could ever possibly do. This is the best analysis. And Kenford still says, despite the fact that this was an all-star expert presentation, it is still too speculative because it piled assumption upon assumption upon assumption, which is exactly what happened here. As for Illinois versus New York law, INDEC argued that that New York law should apply. They prevailed on that. And in any event, please look at the Illinois cases. Look at the Illinois cases that are cited in both sides' brief, and what you'll see is that the law is the same in both New York and in Illinois. When the claim is duplicative, it has to be dismissed. There is no difference. And again, I would just say, I get that the trial court was not pleased with some conduct by Merced and its former counsel, but that is not of justification to completely ignore decades of precedent. Again, if you look at Kenford, Ashford, Goodstein versus New York, this court's decision in RXR2, that is the law. If allowed to stand, this will be a drastic change in the law. It cannot be that because there's a confidentiality agreement where the parties intend to protect confidential information, that somehow converts into evidence of an intent for there to be lost profits. The rule has always been if you intend certain things in a contract, there are regular, ordinary remedies you can get. For example, they sought injunctive relief and then they dropped it. There's all sorts of remedies, but the question is not whether or not you intended to keep confidential information confidential or if you intended to make a profit on a business. It's a non sequitur to go from that to then saying that the parties intended lost profits. And this was a summary judgment ruling. And again, on summary judgment, there was evidence that the parties did not intend lost profits because it had the same silence as in Kenford, and it had the same exact three provisions in the confidentiality agreement as in RXR2, where the First Department said that does constitute evidence that the parties did not intend lost profits.
Thank you.
Thank you, Your Honor.
There's rebuttal still. We're not done. You have 2 minutes of rebuttal.
Thank you very much.
And then you can shake hands.
There's no reason we can't be civil during the argument as well. First, on the point of the intention of the parties, I thought Justice Schechter actually wrote a beautiful first paragraph in her opinion where she said, confidentiality agreements are ubiquitous in the business world, greasing the wheels of complex investments where the parties are wary of potential competitors stealing their know-how. and doing the deal itself. The failure to enforce such agreements would stifle investment and foreclose potential fruitful partnerships. You have to be able to enforce the penalty here. The parties clearly intended that they were going to profit from this. We're entitled to lost profits after we've proved up this breach. Otherwise, these contracts would be meaningless. And the parties could have decided that they didn't want to include lost profits. And New York, of course, is extraordinarily deferential to the wishes of sophisticated parties as set forth on paper. But that's not the wish of these parties. The wish of these parties was what paragraph 8 said, which is that all available remedies at law shall be available for a breach. So that's clearly the case here on the point of lost profits. And on the issue of whether there was a business, I'm sorry, about the duplication of the claims, it's very clear the damages are different. And so you look at that, and I think that answers that question. The last thing I'll leave you with is that this court in Security Pacific, we heard several times my colleague here talking about this was done on summary judgment. Bald conclusory assertion and speculation is not enough in the face of facts and evidence that was there. And in Security Pacific, this court said that the decision of a fact-finding court should not be disturbed upon appeal unless it's obvious that the court's conclusions could not be reached under any fair interpretation of the evidence. And I believe that the evidence here was interpreted not only fairly, the evidence screamed. It screams out from these opinions as to the bad conduct that these people engaged in. And for that, we're entitled to keep our verdict and go back to the trial court and get our punitive damages as well. Thank you very much.
Thank you both.
Your Honors, I want to add to the cites I gave you showing no waiver. We also...
Counsel, your time is up. I gave
Oh,
7 and
I
2 to
apologize.
each of you. People versus Jameer Sneed. You may begin.
Good afternoon. Naila Siddiqui for Appellant Jameer Sneed. The trial court erred in summarily denying appellant's motion for a state action hearing. This case is exactly like this court's decision in Flanders. Just as in Flanders, defense counsel here, at the time of the initial motion, had no information about the security guards in question.
So in the complaint and the VDF, did it include the name or that the person was an employee or any other identifying information about the person who would have, or whether they were a personal individual or an employee? Anything about the person who made the arrest?
No, the felony complaint only said that it was a person known to the district attorney's office, and the VDF made no mention of the name, employment status, or licensing, any information about the security guard.
And what does that mean, person known to the district attorney's office?
That's usually the terminology they use in all felony complaints to...
In other words, they know who it is.
They know who it is, but the defense counsel doesn't know who it is.
Right.
So they did not know the name of the person, the position or title, or the licensing status. Defense counsel only knew that the store was Bergdorf Goodman, the same store in Flanders as the parties' briefs in that case made clear. In Flanders, this court held that at the time of the initial motion, defendant did not have access to any information that could have aided him in further investigation of the security guard's licensing status. The same applies here. There is no meaningful distinction between the record in this case and the record in Flanders, Green, or Mendoza. This case should be remanded for a state action hearing. And this case is unlike Robertson, where the prosecution did actually disclose information about the security guard. In that case, they did disclosed to defense counsel the specific job title. And here, the prosecution concedes that no such information was disclosed. The prosecution simply made a summary claim that the security guards were private actors without any factual support. If your honors have no further questions, I reserve the rest of my time for rebuttal.
Thank you. Okay.
Good afternoon, Your Honors. Jared Walkowitz for the people. Your Honors, I'm going to go right to Robertson. Robertson requested three things of the people, or they noted three things: the title, the name and location of the store, and the precise date and hour. And the purpose
So
behind
let me just make sure I understand what you're saying. In Robertson, they disclosed the specific job title of the person who made the arrest.
That's correct.
That wasn't done here.
That's correct.
Okay.
But
you want us to follow Robertson,
we want us to follow Robertson because
even though the
Robertson
facts
could not have.
are not the facts here.
They are the facts, Your Honor, because our
You
position,
just told
as I
me
wrote
that
it,
in Robertson, the specific job title was given, and here, not at all.
well, if I may,
Yeah.
what I would like to say is in Robertson, it cannot. It makes no logical sense. And if you analyze Robertson, you'll see that the store security guard title was anything to do with the decision. It says even in Robertson, instead, defendant did not even attempt to ascertain whether the store employed anyone with any kind of official police status. The point of Robertson is if you have a store, a date, a time, and an incident, you could subpoena the information. The point of
What would this subpoena look like in this case? What would the subpoena say to Bergdorf?
We have an incident report for the defendant's name at Bergdorf Goodman on such and such date, and was any person involved a police officer? It's very simple. And that's what the reason Mendoza, that's why when...
But we don't even know from the information that's provided when you describe an individual with no title that they were actually employed by Bergdorf, at least in the initial documents, before the people responded to the motion and said it was a private security guard. In other words,
that's not true.
at the time, what
in the motion, they said a security guard or other private individual.
Let me ask my question. What information in the felony complaint and the VDR in the form it leads to the conclusion, or it specifically says that the apprehending individual, the person who did the search, is employed by Bergdorf?
There is none, but again,
we agree.
That's obviously information defense counsel had at the time he wrote the motion, because in the motion itself, he wrote a security guard or other private person. He knew it was not a police officer. It's in the motion, like literally there.
Only because it's like pure speculation. It's like, I don't know.
They're purely speculating. You're saying...
Wait a second, look. You're saying because the defense attorney wrote in it security guard or other private person, they knew that there was a security guard?
No.
And they weren't just asking for putting something in to try to narrow the parameters of what they were seeking?
Well, no, Your Honor, that is a motion that they're writing an affirmation in which they're stating specifically that this is what happened, that it's a security guard or other private person. They're not saying it's a police officer. They're not making any notation from the defendant that the person who stopped him was wearing a badge, that the person who stopped him had any police clothes, that there was any police officers there. They said he was stopped by a private person or a security guard inside Bergdorf Goodman. Robertson says...
You mean they should have said, or an undercover police officer?
What?
They should have said, or an undercover police officer. Had they said that, then this would have been a different situation?
It could have been. I mean, they could have had a hearing, but again, I go to Robertson.
So what you're saying is that there's no need to provide any information, because, I mean, any defendant presumably would be able to say, I was arrested at Bergdorf Goodman, on this date at that time. I mean, they're going through arraignment. Anybody's going to know the day they were arrested. That's kind of obvious. Nobody needs to give any information.
Well, then Robertson basically,
Is that what you're saying, that nobody needs to give any information?
I'm not saying nobody needs to give any information. I'm saying the information here was perfectly sufficient that gave you the date, the time, the store, and you could have then subpoenaed Bergdorf Goodman to see if anybody there had any connection to the police. It's
And so what if then it was what if it was a private person and Bergdorf Goodman didn't have that information about them?
Well, if it was a private person.
I mean, in other words, Bergdorf Goodman only would have the information about the person within their parameters.
But we knew that when the people responded, we said a private security guard. So that issue's over. That issue is not a contention of fact anymore. So if it was somebody else, as you said, the people didn't know it, they responded, said it was a private security guard. It's their allegation.
Wait. We can't look at what your response is, because the question is, under the Court of Appeals authority, is what's sufficient to get you a hearing in making the motion to begin with. So based on the information or that they had or didn't have, was it sufficient?
No, but again,
not what you responded. We can't even look at that.
I'm going back to Robertson. Your Honor, I'm going back to Robertson. And if they would have subpoenaed, as you stated, if they would have followed the rule of Robertson, instead, the defendant did not even attempt to ascertain whether the store employed anyone with any kind of official status. If that
Yeah,
was the case,
but in Robinson, you had the name and the job title.
you do not have the name. You did not have the name in Robertson. You did not have the name.
Okay, you had the specific job title.
You had the specific job title, but here, if you would have
And when you have a job title, implicit in that is that they were hired, they were working for the store institution.
In fact,
that's not present here.
In fact, it said the title was Loss Prevention Associate, and they had the name and the location of the store. So for example, Bergdorf Goodman, the address, it was a Loss Prevention Associate. Now one might put two and two together from that and figure, well, this person is employed at
Well, in Mendoza,
Bergdorf,
they didn't
that's
have,
why they
sorry,
have this.
sorry.
Yeah, go ahead.
In Mendoza, nowhere in Mendoza does it say they had the store name. That seems to be the problem, right? Because in Mendoza, you could not.
They had even less. That's what that says. They had even less.
Well, I don't know if the Court of Appeals would
The
say.
defendant is arrested in the store. I mean, are we really saying that the defendant is arrested and the defendant wouldn't know the store? Now you're saying that the Mendoza is significant, not because it didn't give a title or a name or anything, but because they didn't give the name of the store. No, they gave even less, not even the name of the store. But you know what? Most defendants, whether they're going to say it or not, know the name of the store.
Then I don't understand why in Robertson this court wrote that the person could have subpoenaed Bergdorf
What
Goodman.
I don't understand is why you, where there is the name of the associate, the name, the title in Robertson, why you want to say, oh, but that's not important.
Because
that's the very thing that's different between this case and Robertson, and you want to say, ignore that.
But what I want to say, I'm sorry about that, Your Honor. What I want to say is that it would make, to me, based upon the language of Robertson, no logical sense that the loss prevention associate would matter if the point of Robertson is to subpoena the store to see if anybody worked at that store who had a police connection. Then, when we said that this was a security guard, that would have ended it. We would have known it wasn't a state action officer if they would have done what this court in Robertson instructed them to do. They did not do that here.
Thank you, counsel. Thank you. Yes?
Your Honor, the information was not exactly like Roberts. Just like in Flanders, we knew the date and the store, and no more information other than that. Had the prosecution provided information about even the title, the name of the person, then we could have subpoenaed asking.
Well, isn't he saying, I'm not saying I agree with it, but isn't he saying if the defendant knew he was arrested at Bergdorf Goodman on such and such a date at such and such an hour, that would be enough to subpoena, to issue a subpoena and say, please give us the names of all employees in the security department at on that date at that time in this store? And was anybody else who was not employed by the store, including an undercover officer, involved in an arrest at that time, at that place, at that store? I think he's saying that there could have been a response to a subpoena like that. That's what I understood.
Yeah, well, this court has made the distinction between what was available to the defense at the time, and at the time of the initial motion papers, that information was not required. We based on the information we had, that was enough to get a hearing to determine whether or not the officers or the personnel that stopped, searched, and arrested Mr. Sneed were state actors, had any specific licensing authority, and without knowing who it was or what their status was, there was no way for us to meaningfully get that information within a reasonable time for the initial motion papers.
Thank you. Thank you both. Alstacher versus Clark. I'm recused from that case.
May it please the court. My name is Adam Ostacher. I am the appellant.
Set up. Just give me 1 minute, okay?
Oh, I apologize.
It's always the hardest. Okay, Counselor, you may proceed.
Thank you, Judge Kennedy. This FOIL-related appeal arises from the Bronx District Attorney's Office large-scale destruction of case records and evidence in 5 homicide convictions in violation of New York County Law 700, subsection 7, and New York City Charter 1133, subsection B, both of which specifically require respondents to preserve the records they destroyed. Respondents have further admitted that they haven't told anyone, not the defendants, the attorneys involved in the cases, not the mayor's office, as they are legally obligated to do, that they destroyed records in these cases that they are legally mandated to preserve. In response, respondents have argued that District Attorney Clark is an independent constitutional officer, and as such, she doesn't have to comply with the New York City Charter or with New York County Law 700, which put forth the essential duties and responsibilities of a district attorney. There are 3 sets of FOIL requests at issue in this appeal. Those in September of 2019, there are 5 in each set. Those in January of 2020, and those in May of 2020. Addressing the September 2019 FOIL request first. After I submitted these requests in early September, the District Attorney's Office set a date certain, 3 months out, in early December, for them to respond to these FOIL requests, either to deny them or to grant access to the records. During that 3-month period, the District Attorney's Office did nothing. They didn't reach out to me. They didn't extend the date certain. As such, in December of 2019, these FOIL requests, date certain, they expired, they lapsed, and there were constructive denials of these 5 FOIL requests because they ignored them for the entirety of the 3-month period they set for their response. This by itself is a statutory violation pursuant to Kohler-Hausman, requiring awarding of attorney fees pursuant to PBO 89-4C. I would further note that after I appealed these constructive denials, and this appeal was ultimately granted, respondents' appellate FOIL appeals officer remanded the FOIL request back to their FOIL records access officer. This is a delaying tactic that respondents have come up with, and it violates PBO Law Article 6. And this is noted and found explicitly in Advisory Opinion 19780, which I cite in my brief. Article 6 requires that after an appeal, an agency must either provide records or deny access to them. An agency is not permitted to remand FOIL requests back to itself. The lower court, the Article 78 court, found this statutory violation to be reasonable, even though statutory violations can't be found reasonable. And she found it reasonable because it was only 60 days long. That was her finding. It wasn't 60 days long. It was over 3 months long. The reason the lower court made this erroneous factual finding is because respondents made a factual misrepresentation to the lower court that the delay was only 60 days when they knew it was over 3 months. And even after this factual misrepresentation was brought to respondents' attention, they chose to let it stand. Lastly, on this point, respondents have not provided a single record in response to the September 2019 FOIA requests in the 2 years since I submitted them.
I know that there's 3 sets of requests, and I know that there was up and back, and I don't want you to have to spend your whole time filling us in on the facts, because we did read a lot of this. But wasn't there an indication that that you did get a rolling, that there was some type of rolling production? So you have gotten some of the documents. I'm not saying that's the answer to the ultimate question, but you did get some documents over a period of, since you've originally.
FOIA requests that are not the subject of this appeal, I did get here and there a few FOIA responses, and those are the subject of this appeal. But yes, that is correct. And what that does, because part of their defense of this is they're claiming that they were closed. The fact that they can give FOIA records shows that they were open and fully capable of providing the FOIA responses that I requested. So that really jumps ahead to the July 3rd, 2020
date, right?
Violation of all 3 sets of FOIA requests. Because if they're open, which they were, and if the COVID-related executive orders do not apply to FOIA requests, which the Committee on Open Government found they don't, and which I argue they don't, because as this court has found repeatedly, going back 30 years, there is no specific deadline for an agency to respond to FOIA requests, which takes it out of the realm of all of those executive orders. If you have that, if they're open, which what you just said provides they were open and able to provide these responses, you then have statutory violations as to every single FOIA request that is a subject of this appeal.
Did you get from them any responses that said the things you're asking are privileged, they're too broad or specific, those kinds of requests, those kinds of responses?
Not for these. Not for these FOIA requests. And that would be a claim, that would be an exemption, right? And the reality is for these FOIA requests, I never got any substantive response, any claim that any of the documents that I saw, the public records, the presumptively available public records that I saw, were in any way privileged or otherwise exempt. And public PBO Article 6 lists the specific categories of exemptions. For these FOIA requests, there was nothing. And in fact, just going back to the good faith and if they were closed or not, on June 27th, about a week before the final date certain that brought this about.
July 3rd, 2020, a year ago.
Of 2020, exactly. I sent an email to respondent's FOIA records access officer saying, because I have to pay if they're going to send me a disk, I sent him an email saying, can I send my $5 check-in right now? A week before the final date certain, he responded saying, I don't need a check. I'll send everything by email link. And then, a week later, the date certain he set for his response, he didn't tell me anything. If he had simply emailed me and said, I need more time, we wouldn't be here. So there was a final statutory violation. And that by itself requires a finding that I have to get all the records. They cannot claim any exemptions now pursuant to Malloy. Because they didn't claim them before the statutory violation took effect, they cannot claim them now, and I'm entitled to costs and fees.
You'll have time on rebuttal. Thank you.
Thank you, Judge.
May it please the court, Rafael Corbello for the Office of Darcel D. Clark. From September of 2019 to June of 2020, petitioners submitted 62 FOIL requests. Respondent has rendered determinations on 36 of those requests. In fact, 14 of those determinations came during the COVID-19 restrictions.
But isn't that besides the point? That doesn't relieve you of the obligation to otherwise respond to the ones that you haven't responded to, right? You'd agree with that.
Yes, Your Honor, I do agree with that. But the Article 78 court was correct that the delays in responding to the 14 outstanding requests at issue here were reasonable under the circumstances. And so that begs the question, what were the circumstances? And I submit to you there were 3 circumstances, one of which is the requests themselves, the sheer number of requests and the nature of the requests, many of them very technical in nature, requesting emails, metadata, even social media postings and things of that sort, which required coordination with the Department of Information Technology and Telecommunications. So that's one circumstance, the nature of the requests themselves. Second, the other 2 circumstances are quite unusual. The first is the sweeping discovery reform that went into effect on January 1st of 2020.
I mean, I understand that. I know that there was COVID. I mean, we obviously are aware, and we're also aware of the discovery request that went into effect. My question is that petitioner did not commence this particular Article 78 proceeding until your response, which was, I don't know when you're ever going to get them. Which is, I mean, is that really an appropriate response? I mean, don't you have to give him a petitioner some type of framework? I mean, not, well, that's maybe sometime in your lifetime I'll get to this, but we're a little busy now.
That's why I mentioned that 14 of the determinations were in fact rendered during the COVID-19 restrictions. And we read Executive Order 202.8 as tolling the time provisions for FOIL, as did the Article 78 court.
I know, but I have to admit, it doesn't seem like a real good fit. I mean, that executive order seems to be addressing something else. I don't know how else to otherwise frame a question. It doesn't seem like a real good fit.
Well, the executive order speaks in terms of any process as prescribed by any statute.
Yeah, I mean, I kind of looked at that, and I could be wrong, that the executive orders and the administrative orders that came following that were concerned a lot about statute of limitations in cases that had like 3 years, and if it's 3 years and 1 day, you're out. And they said, that we got to toll that like they did after 9/11 and things like that. And that's the way I saw it. You really don't have a specific amount of time, but you didn't even respond in saying these are very burdensome, but we need 6 months, or these things are privileged and we can't protect. I mean, you didn't respond in any way. And I know it was a lot of responses, but
we didn't invoke any exemption. We didn't invoke any exemption, but we did in January 3rd of 2020, we laid out that the sheer number of requests and the nature of the request and the limited resources that we had, given the number of the request and the nature of the request, we laid that out in January of 2020 to explain why it is, we were able to respond to 22 of your requests so far, but we're going to need about 6 months in order to.
But the reality, I'm sorry.
No, just that, you gave a specific deadline, though. At least when it came back from the appeal,
but we
you gave a deadline. You say, all right, we're going to take care of this by a certain date.
Right, but we could not have anticipated what came afterwards. We could not have anticipated the closure due to the COVID-19 pandemic. If you read the executive orders and the administrative orders in conjunction, you get a sense of who the essential personnel are, what the essential functions are, and you look at the administrative order 7820, and it lays out the essential functions would be arraignments, bail, SORA hearings, resentencing, orders of protection. FOIL was never, ever listed as an essential function, not in any of the executive orders, not in any of the administrative orders. And so we reached the point where we just could not have our employees commuting to work, spending the day in the office, commuting back home, because the mere act of commuting would have mitigated the city's attempt, or the state's attempt, to mitigate the spread of the COVID-19. That's the situation that we found ourselves in. It's a very unusual circumstance that needs to be taken into account. And the fact that we were still nonetheless able to render determinations on 14 requests show that we were not simply sitting around twiddling our thumbs, but that we, to the extent that we were able to render determinations despite the COVID-19 pandemic, shows the good faith with which we pursued his requests. But they are extensive, they are highly technical in nature, they require coordination with IT staff that was burdened at first with the implementation of the enhanced discovery obligations, and then thereafter trying to get every single employee of the Bronx DA's office to be able to work remotely. Both of those undertakings were all hands-on-deck operations.
So let's talk about the IT work, because I know you also indicating that the IT department had to finish the task with transforming to remote work. But you didn't even give any indication as to when that would be finished, when they could start with the 4 requests. Nothing.
Because the person who's best suited to have that information would have been the director of the IT unit, and he was unavailable given the circumstances. And so he couldn't tell us, for example, when he was going to be finished perfecting the technological advancements that needed to be put into place in order for us to be able to comply with the enhanced discovery obligations, because after January 1st of 2020, I can assure you, everything was not perfect. And so you don't know how many cracks and holes you have in the dam until the water comes. And so even after January 1st, 2020, we still had to address the discovery obligations. That's what our IT unit was busy with. And then came COVID and the remote access, and that swamped them as well.
All right, just please wrap up your argument. You're out of time. Thank you.
Just very briefly, this is raised in my briefs, but every argument he just raised is not supported by evidence at the administrative or Article 78 level, right? So the agency bears a burden of submitting evidence to support a denial of access to records. You look at Markowitz, its progeny, you look at New York Committee of Occupational Health and Health versus Bloomberg, you look at HLV Associates, which is cited and relied upon in Malloy, and you look at Malloy, it is clear that an agency must submit evidence at the administrative level when it is denying access to public records. And this is not Webster's Dictionary law and order TV evidence. This is how you have defined evidence as.
So we can't really consider the fact that COVID-19 and the effects of it on the court system and on the institutions that are involved in law enforcement were affected by the pandemic. We can't take that into consideration?
Of course you can. But when it comes to whether or not their IT person was unavailable, when it comes to how many records, all they had to do, and you look at, Justice Kennedy, you were on that recent, Aaron Law versus Department of Education back in the spring term, right? And that was the case in which the Department of Education, in order to sustain their burden, their records access officer submitted an affidavit. That's all they had to do. So if they were closed, COVID, you can consider COVID, of course you can. But as far as the factual representations they made, if their IT unit was available, if Ray Vasquez was the only person in the whole world who could help with this, if they were closed, all those issues, they have the burden, they have to submit evidence. And at the lower proceeding, all they had to do, if it was true, is sign an affidavit. What they have at the lower proceeding is emails and unsworn correspondence. And lastly, on this point, you haven't really addressed the lower court. The lower court really overstepped what an Article 78 court can do. It raised its own exemptions sua sponte, exemptions that are not recognized in Public Officers Law Article 6. It denied access in total to records, not just saying we need more time, it denied access, and the District Attorney's Office has adopted that. So without giving any evidence, they're denying my FOIA request in total. The reality is, this is a case of massive misconduct in which they destroyed DD5s and witness statements, original copies, and people are in jail for life on this. And they're saying, it's just copies, we're giving you nothing on this. Those claimed reasons, which are unsupported by evidence, they're pretextual. The real reason they don't want to give over these records is because
We're
they don't
not
want to give
looking at
over
motivations, we're looking at whether the FOIL was complied with. So I appreciate your argument, but thank you.
Thank you all, I appreciate it. Take care, be well.
Eight Jane Street versus Patron.
May it please the court, my name is Charles Weinstock. I represent the defendants' appellants, Mr. and Mrs. Petroni. As you know, the plaintiff has been eager to turn this argument into a debate about where exactly the property line should be drawn. It doesn't matter where the property line is drawn. Here's what matters. As this court wrote in 2013, and I quote, "An owner may not do anything on top of the party wall which would exclude the other party from its equal use," unquote. That case is 145 West 10 Realty, 107 AD 3rd, 461. It's undisputed that the plaintiff has built a rooftop parapet and bulkhead that occupy fully 7 of the party wall's 8 inches. Not only does that deprive the Petronis of equal use, it deprives them of any use at all. And the injury here is not just whether they can put up a flower box or some decorative pots atop the party wall. It's whether they can build an extra floor on their house. The Petronis are in their 70s, and townhouse living is increasingly difficult for them. They may soon have to sell it. The right to build another floor in a neighborhood like the West Village dramatically increases the value of the property. Plaintiff never questions the only appraisal of the extra floor, somewhere between 1.8 and 2.8 million. And that's back in January 2017. The problem, though, is that to build another floor, they need load-bearing walls on either side, and the bulkhead is decidedly not that. It's steel studs and hardy board cladding, a slurry of wood pulp and cement. Plaintiff never disputes that 7 of the 8 inches have been annexed by them.
Is the bulkhead where that stairway to
Yes.
their additional floor is?
Yes. Well, it's not an additional floor, it's to the rooftop.
The rooftop?
Yes.
Okay.
Yes.
Thank
So I was saying that, the plaintiff doesn't dispute that 7 of the 8 inches are in fact annexed by them. It doesn't dispute that it will not support a new floor. And it doesn't dispute that the loss is millions of dollars. That should be the end of the story. Under settled New York law, they should take the structures down. Now, plaintiff doesn't want to reckon with any of this, and it puts its eggs in one basket, that the property line lies at the midpoint of the wall.
Well, even if that's true, wouldn't there at least be an encroachment of 3 inches onto your client's part?
There would, and
Party
that would constitute a trespass.
Yeah, and I'm not actually necessarily deciding or disagreeing with your concept that a party wall, regardless of where it lies on the lot line, is subject to the use of each person to the whole of that party wall. I understand that's your position about what the law is on party walls.
Right. Yeah, it's 100 years of jurisprudence
Yeah.
in New York.
In fact, there's no dispute it's a party wall.
No.
Yeah.
So I don't want to get into the bog of reviewing the title surveys, and figuring out who has the superior documentary evidence about where the property line is located. I want to make a single, simple and dispositive argument about why the entirety of the property, the party wall is on the Petroni's property. I don't know if you saw the picture in the record, but the Petroni's house extends a few feet beyond the plaintiff's house in the rear. So for those few feet, it's obvious that the party wall is on their property because there is only a yard on the plaintiff's property. It's difficult to imagine why that party wall would not continue in a direct line to the front of the house, in which case the entirety of the property of the party wall would be on the Petroni's property. In the deposition, the plaintiff's surveyor proposed, without any evidence, that perhaps the Petroni's house has two walls, one for the last few feet and another for where the house abuts the neighboring house. According to the plaintiff, this exposed wall is exactly 4 inches over. Now, it can't be a coincidence that those 4 inches are precisely what the plaintiff needs to make the argument that the property line is halfway down the 8-inch party wall. It just doesn't make sense. Moreover, we've reviewed the fire insurance maps from the mid-19th century. There's a link to the New York Public Library website on page 18 of our first brief, which will take you there. But they make clear that the entirety of that side of the Petroni's house consists of a single load-bearing wall, both where the two houses abut and where they don't. But let me give the final word on this debate to the owner of the plaintiff LLC. His name is David Wine. When asked about his survey's property line, he said, and I quote, "I don't believe that the line is intended to be a representation of the legal metes and bounds. It could be that it represents generally a property line, as opposed to exactly a property line." End of quote. That's at page 600, 601 of the record. In a game of inches, clearly that won't do.
Sir, so at the very least, what you're really saying here is the court below erred in granting them summary judgment on the issue or declaring that the party line is in the middle of the road.
Exactly. Yes, both the private nuisance and the declaration.
Fair enough.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Mona Simonian for representing Plaintiff Respondent 8 Jane Street, LLC. This case arose from what the Supreme Court found was the patron's, quote, pattern of recurring objectionable.
I don't think that's really going to help you in terms of the legal arguments to be made here. Go ahead.
Yeah,
move you off your argument. I want to hear more substantively about issues of burdens of proof and surveys and proving property lines and party walls and legally what the rights are of parties to parties.
Sure, Your Honor. Here, there actually is no, despite what my adversary had said, there actually is no debate about where the property line falls and what was built on top of the party wall.
Or that it's a party wall.
That it is a party wall. That is undisputed.
Regardless of where the property line is.
What is also, I'm sorry?
Regardless of where the property line is, it's a party wall.
That's correct.
Right.
And what is also undisputed is the law governing what a party can do with that party wall, with the party wall. It's undisputed that where two properties share a party wall, either party may build upon the entire width of that wall, so long as it does not prevent the other party from equal use and access to that wall.
So don't we have in this case, we have competing expert affidavits about whether in fact the patrons have been deprived of their ability to use that party wall consistent with the law, as you have just articulated it, that would require a trial?
No, Your Honor, because the only expert who actually weighed in on how the party wall was built up and extended and had the bulkhead built atop that party wall was plaintiff's expert, who was also the contractor on the case.
There was an engineer, not an architect. I'm speaking.
Oh, sorry. Okay.
There was an engineer, not an architect, who the defendant presented.
That's correct.
Okay.
That's correct. But also, Mr. Flynn, who was the defendant's expert, who was the engineer, was also testified he never saw how the bulkhead was built atop the party wall, what was inside. He literally looked in between the siding and made determinations, or speculations, I should say, that they were built using wood studs, which isn't true, and also that they used cement that was not fire rated, which also wasn't true. Mr. Ruddy, who was the plaintiff's expert, actually provided detailed testimony, which this court can find at 295, R295 to 296, as well as 243 to 245.
He was actually, Mr. Ruddy was actually, he's an architect, right? And he was actually the GC for the renovation that the plaintiffs did.
Yes, Your Honor. But he also served as an expert for this purpose.
Yes, I understand that.
Right, which is that he was presented with several questions about hypothetical potential construction the patrons may want to do in the future, and how the party wall extension, as well as the bulkhead, would or would not prevent it. And on pages R243 to 245, he provides extensive detail about the fact that the bulkhead was intentionally built sufficiently strong so that, should the patrons want to engage in construction in the future, add another floor, for example, he provides detailed explanation of how that can be done by attaching to the steel studs of the party wall, as well as if they wanted to add floor joists to the masonry of the extended party wall, that the structure of the party wall and bulkhead were built intentionally with sufficient strength to support any construction that might be performed in the future by the patrons. That isn't disputed here, and quite frankly, the patrons haven't presented any other evidence that would say otherwise. In fact, their appeal brief only cites to one citation in the record for the claim that the plaintiff's contractor, 8 Jane Street's contractor, supposedly testified that the bulkhead was unavailable for use. But in fact, the citation that's cited there is actually to Mr. Flynn, the defendant's contractor, who himself admitted he never saw what was inside or was built, or how the bulkhead was built, or whether or not it was sufficiently strong. He didn't have that information. So with respect to that, given that, the fact that they extended up the party wall and built a bulkhead atop that party wall using 7/8 of an inch, this court has repeatedly found that's completely allowed so long as the patrons can use that wall as well. And the only evidence in the record shows that they can. In addition, wait
a second. Didn't their expert disagree with that?
But their expert did not ever examine the bulkhead or could not make any determinations as to how the bulkhead was, whether or not the bulkhead was built sufficiently strong, He was only...
So isn't that an issue? I mean, I don't know if you didn't give him access. I don't know if they asked for access. I mean, he didn't build it. He's coming after the fact. So I'm wondering if that's some kind of an issue that has to be determined before the court, any court, can make that ultimate determination.
He was certainly entitled to review the bulkhead. He didn't. He chose not to. He made speculative statements in a supposed expert report without ever actually having any factual basis to do that. With respect to, just very quickly with respect to the property line, Your Honors, there actually is no dispute specifically because the party line, the location of the property line running through the midpoint of the party wall was proven not only by plaintiff's license survey and the affidavit of the surveyor and the deeds of both plaintiff and defendant's properties, but also the defendant's own commission survey, which the patrons have failed to even acknowledge, but they themselves commissioned a 2012 survey by a licensed surveyor that contradicts the very claims they're making now, and actually showed that the property line ran through the midpoint of the party wall. So there's no question that the party wall was shared and straddles the line. Therefore, there was no actual invasion of the patron's property in any way. And unless there was some evidence, which there hasn't been, of any kind of actually weakening of the party wall structure, which they have failed to present, the construction on the party wall is entirely permissible under the law, and there is no encroachment under the law. Thank you.
It's simply not true that anyone testifying on behalf of the plaintiff suggested that this bulkhead is a load-bearing wall. It's not. And whether Mr. Flynn got some of his facts wrong about what's inside the bulkhead, the briefs themselves submitted by the plaintiff describe it for what it is. It's steel studs, which I can bend with my hands, and hardy board, which is a faux wood, 7/8 of an inch in thickness. It's ridiculous to suggest that that constitutes a load-bearing wall, and there is nothing in the record that suggests that it would. Now, the test that my adversary suggests for whether a party wall has been exploited fairly is whether the other party is prevented from doing what it wants to do. Well, obviously, if it wanted to build its own bulkhead, it could not, because 7 of the 8 inches have been taken. To the extent that you conclude, and it's an inescapable conclusion, that the bulkhead is not a party wall, the defendants, the patrones, are prevented from doing something worth $1.8 to $2.8 million. It's as simple as that.
Thank you. Thank you both. Renee B. versus Jeffrey B.
Good afternoon, Your Honors. Renee Kathwala for the appellant mother, Renee B. This appeal concerns the enforcement of a motion to compel a subpoena that was served.
You just said something I think is very important. It was a subpoena about the agency's enforcement, what they were doing, what they did.
Correct.
It wasn't something to force the agency to act. And they did provide information about what they did, didn't they?
No, they didn't.
No?
The record is very clear here, and the support magistrate, for some reason, concluded that the agency complied with the subpoena. However, if you look at my reply brief and look at the transcripts in this case, it's very clear. The agency showed up with counsel on January 6, 2020. They said, oh, we have automated records. We can't provide you with any documentation or information. We need an adjournment to come back and provide documentations. They showed up on February 27th, 2020 with different counsel. Counsel said, oh, we didn't confer with our other colleague. We don't have documentation. So the support magistrate said to SCU, come back on March 2nd at 4 p.m. if you're not going to produce records. If you produce records, provide those records to counsel. That was me. 12 p.m. went by, no records were produced. Instead, a third counsel for SCU showed up on March 2nd, and she made arguments about whether the subpoena was validly issued. The problem with that argument is they had waived the defenses to the service of the subpoena when they appeared initially and said, here is an affidavit saying that these records are automated and therefore we can't produce documents today. We need more time to produce documents thereafter. So for whatever reason, the support magistrate...
On that date, didn't they also, wasn't there a discussion about the fact that there was the subpoena hadn't been registered in Israel, I guess, because it hadn't been translated to Hebrew?
Well, I mean, the subpoena really, no. This is the reason
judgment,
my
the
client was
support order, the support order.
Right. There was separate discussion with the father's counsel and efforts to register the order in Israel, which was the whole point, just so the panel is aware, I'm sure you are, but SCU is the Title 4D agency. They're the only ones that are able to enforce the order in Israel where the father fled to with the arrears in greater than $150,000. That's why my client is interested. 2 years later, as I stand here today, we still don't have any enforcement of the order, and we don't have any evidence that the SCU has done anything to enforce this order in Israel. We are simply asking the subpoena, which is very broad and asks for all efforts that the agency made in connection with enforcing the subpoena to be turned over. And again, the family court judge says there is a reasonable basis supporting the magistrate's order. Great deference should be given to the decision of the trier of fact who is in the best position to assess the credibility of the witnesses and the evidence proffered. We agree with that. The problem is there is no reasonable basis, in fact, because the support magistrate himself held that they didn't comply. He ordered them to comply twice, once on February 27th, once on March 2nd. They failed to turn over any documents or information about any enforcement in Israel. And that's why the support magistrate and the family court judge committed legal error, because they simply abused their discretion in finding that the subpoena had been complied with, when in fact the factual record is absolutely crystal clear it had not been complied with.
Thank you.
Thank you.
People versus Ryan Rohan. You may begin.
Thank you. Good afternoon, and may it please the court. Matthew Christiana on behalf of Ryan Rohan. Mr. Rohan was denied the effective assistance of counsel below, where counsel failed to secure an adequate reasonable doubt instruction, which would have instructed the jurors that the lack of evidence was a permissible consideration, and two, where counsel failed to object to the pervasive misconduct that spanned the length of the prosecutor's summation. These errors here are reviewable on direct appeal because the record demonstrates that there was no reasonable explanation for counsel's conduct in light of the evidence presented and Mr. Rohan's defense. In this case, the prosecution's evidence was based on a single unreliable witness. There was no forensic evidence, no other eyewitnesses, and no surveillance footage. It hinged on the inconsistent testimony of an unreliable complainant who used marijuana and heroin the day of the incident and used heroin before she took the stand at trial. In response, the heart of Mr. Rohan's defense was that the complainant was incredible and that there was a lack of convincing or corroborating evidence. And despite this, counsel failed to secure the precise charge that would instruct the jurors that the lack of evidence is a consideration, and counsel allowed the prosecutor to, among others, attempt to shift the burden and incessantly vouch for the complainant's credibility. With respect to the reasonable doubt instruction, the lack of evidence was the central theme that was woven throughout the entirety of the defense, from voir dire to summation. During voir dire, counsel informed the jurors that while surveillance footage is not required, the lack of it is still a permissible consideration that they would be instructed to consider. Then throughout trial, counsel introduced photographs of the incident location, purportedly showing surveillance footage at the location. Counsel elicited on cross-examination that the officers never visited the scene, that they never canvassed for witnesses, and then counsel tied it all together at summation, arguing that the complainant was incredible, that there was a lack of convincing evidence, and despite the availability of security cameras, there was no surveillance footage because everybody in this case just assumed that Mr. Rohan was guilty.
Counsel,
Yes.
the the claimed victim or the witness that you claim was incredible knew the defendant, knew your client. That's not really an issue, correct?
No, Your Honor.
And she accused your client of threatening her with a box cutter. And when the police arrested your client was found with the box cutter, correct?
Yes, Your Honor.
Oh, so there's other information that essentially is undisputed that pretty much corroborates the claim.
Yes, Your Honor. Well, with respect to the box cutter, precisely that the complainant and Mr. Rohan did know each other. So it's not beyond the realm of possibility that the complainant knew that Mr. Rohan carried a box cutter because Mr. Rohan at the time was homeless, as was the complainant. So just the mere fact that Mr. Rohan had a box cutter on him does not sufficiently establish the elements of this offense. And with respect to the summation point, the outcome in this case turned in no small part on the jury's resolution of the complainant's credibility. These issues should have been resolved by the jury on the basis of the properly admitted evidence. And the prosecutor's summation here attempted to divert the jury's attention away from that. And counsel should have sought to stop that. And notably in this case, in the respondent's brief, they acknowledge that, at least as far as the impermissible attempt to shift the burden goes, that those comments were better left unsaid. They were strikingly similar to the type of argument that this court has already deemed impermissible in People v. Collins, and yet counsel remained silent. And finally, I just do want to briefly touch on the sentencing ineffectiveness as well. Mr. Rohan was also denied the ineffective assistance of counsel at sentencing. Sentencing counsel failed to advocate on Mr. Rohan's behalf. And although it's contradictory, he considered this conviction to be based on horrendous acts, although there was no physical injury that occurred here. And finally, sentencing counsel also took an adverse position against Mr. Rohan when he deemed the potential prospective 330 motion, in his opinion, quote-unquote frivolous. He was not outlining his efforts on behalf of Mr. Rohan by considering the motion frivolous. He actively took a position adverse to Mr. Rohan. If there are no questions, I reserve the rest of my time.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Jillian Lewis on behalf of the respondent. Your Honors, here, the ineffective assistance of counsel issue in this case is not properly before this court. Here, the most appropriate action would have been to file a 440 motion, but it is clear based on the facts of the record that each of the defense counsels, and there were 3 total, 2 at trial and 1 at sentencing, was acting rationally and appropriately for their role. There was nothing inherently adverse to the client here, and although appellant counsel argues that at sentencing, counsel equated a 330 motion with being frivolous, that's not exactly what the record indicates. The record indicates that defense counsel explained to the court why it wasn't filing certain motions that the defendant wanted them to, and he was doing so in the client's interest.
He did use the word frivolous, though. He did characterize the 330, the filing of a 330 motion, as being a frivolous motion, did he not?
Your Honor, he did not, because he was talking about multiple motions and how he had described to his client the options and that he did not want to file a motion because it was frivolous. So he did not speak specifically about the motion that defendant wanted to. He was just giving the court the full context of the back and forth. Was
there another motion he had referred to?
Yes, he had talked to his client about the possible other motions to file. In this case, I think he explained as well the process of a 440 motion and the other.
In other words, when he used the word frivolous, he was referring to his client's motions, not some other person's motions. So it was one of the motions that his client had discussed with him, right?
Yes.
So maybe it would have been a better idea not to use that word.
Yes, perhaps it would have been. But if your honors have no further questions, I will rest on the brief.
Thank you.
Thank you.
Just briefly, sentencing counsel did use the word frivolous specifically, although he was talking about other motions, he was explaining the difference of a 440 and a 330, but it was all in the context of a singular motion. And counsel stated specifically, and I quote from page 5 of the sentencing transcript, "I don't believe I have made the court aware that there is any ground for a 330 motion. However, I've explained to Mr. Roman, which is a typo, that he is free to file any motions that he wants, but I am not going to file a frivolous motion," end quote. So that was an adverse position to Mr. Rohan, Your Honor. And with respect to the reasonable doubt instruction and the summation errors here, this is a case where counsel's theme of the defense was lack of evidence, which is evident in the beginning during voir dire. Counsel specifically instructed the jurors that they would be receiving this instruction that a lack of evidence is a consideration that they would get or that they would be allowed to consider. And yet counsel failed to secure the very precise charge that she opened with. So in that instance, Your Honor, the errors are reviewable on direct appeal, and it was objectively unreasonable. Thank you.
Thank you. Telemann Holding versus VCW Associates.
May it please the court, this is Larry Robbins for Appellant Telemann Holding Corporation. This appeal turns on the plain language of a lease that speaks directly to the question presented and answers it. The lease between these parties provided that in the event Congress enacted, quote, a successor statute to Section 216 B1D of the Internal Revenue Code, and that successor statute, quote, permits a greater or lesser percentage of gross income to be derived from the non-tenant shareholders than the percentage of cash requirements chargeable to VCW as rent, quote, shall be deemed modified. This appeal therefore asks two questions. First, is the new version of Section 216(1)D, quote, a successor statute, end quote, to the old version of Section 216(B)(1)D? To ask that question, I respectfully submit, is to answer it. The old version of 216(D)(1).
Let's assume this is a successor statute. So let's focus on the other sections and what was stated in the lease. Does that lease, which seems to be maybe very narrow in what it says about the 80-20, allow for a change now where the statute has added these other two sections that don't relate at all to the 80-20? They relate to different aspects,
Yes.
the square footage, et cetera.
I appreciate the question. So if we're agreed that this is a successor statute, which, by the way, VCW contests, but I think is not fairly debatable.
Well, let's just say, for argument's sake, that it's a successor statute. How do you have this language in the lease?
Yes.
It's very narrow, et cetera.
Yes, and so turning to that question, Your Honor, then the second question is, does this new statute, quote, permit, end quote, a greater or lesser percentage of gross income to be derived from non-tenant shareholders? And the answer to that question is also yes. How does it do that? How does it permit a greater or lesser percentage of gross income to be derived? The answer is it renders the 80-20 statute optional so long as you qualify under one of the other two provisions for favorable co-op tax treatment. And there's no dispute on this record that the co-op owned by Telamon Holding does in fact satisfy one of the two alternatives. And so what Congress did, Your Honor, to go back to your question, what Congress did is it said, we don't want our tax laws to be driving co-ops to be charging below market rents.
Right, that is what it said, but it also then was sort of leaving it to the landlords and the tenants. It's saying, okay, you can go ahead and charge them fair market. You don't have to charge them under that amount. But in this case, what makes it different is that maybe if there was a lease that didn't have reference to this at all, that would be one thing. Or if it just said any change, any successor law, we get to redo this, or any change in it. But this specifically referred to a change in the 80-20 section.
No. Actually, Your Honor, that's what the Supreme Court judge thought, but that's not the plain language of the text.
Okay.
What the language says in precisely these words is that if the successor statute permits, that's the key word, permits a greater or lesser. And so how does this statute do that? It permits it by making the 80-20 rule optional. Imagine instead, Your Honor, that what Congress did was it said, look, we don't want to keep driving market rents down below market. We're going to just jettison, we're going to repeal the 80-20 rule outright. They'd still be making the same argument.
But they didn't do that.
They didn't do that.
Repeal the 80-20 section.
They left it the same, but they made it an option. And that makes all the difference, Justice Renwick. That makes all the difference, because right now, under this successor statute, you have three ways of qualifying for favorable tax treatment. You can still satisfy 80-20, or you can do what this co-op, and co-ops all over the city are doing, which is they're satisfying the law under one of these other options. And for that crucial reason, for that dispositive reason, I suggest, this statute permits, and that's the operative word, permits a different amount of gross income to be derived from the non-tenant shareholder because it renders the 80-20 rule irrelevant, legally irrelevant, if you meet one of the other two standards. And that's all it takes to permit, the operative word. Now, they argue in substance, look, the only successor statute that fits this bill is one that tinkers with the 80-20 numbers themselves. But you can search this rent provision day and night, and you will not find that language there. The parties did not say, Your Honor, did not say, if there's a successor statute that changes the 80-20 numbers themselves, then in that event, you can charge a different amount. No, they said a successor statute. That's capacious language.
So,
sorry, go ahead. No, go ahead.
So the thing is, I've got the language of the lease, and it says that if the successor statute permits a greater or lesser percentage of gross income to be derived from non-tenant stockholders.
Yes.
And you're saying that this would allow that to happen because now there are two different ways for them. They don't have to fall into that category. There are two different ways for the housing co-op tenants to be able to maintain their residential tax benefits.
Precisely right. That's precisely right. And then the last step in the analysis, just to complete the plain language, because that's all you need to resolve this case. The last step in the analysis is this. Once you see that the 80-20 rule has been rendered optional, and you then, because it's a matter of simple arithmetic, the maximum percentage of gross income you could ever get from a commercial tenant is 100% of the gross income. It can never be more. Then under the lease, that 100%, which is the maximum permitted gross income, is deemed to be the percentage of cash requirements that constitute the new rental amount. And I appreciate the court indulging me while my red light was on, and I've reserved 2 minutes for rebuttal. Thank the court.
You're welcome.
Good afternoon, may it please the court. My name is Deborah Koplovitz from Herrick Feinstein for respondent VCW Associates. If there's one thing that we can agree on in this case, it is that the plain language of this lease controls. And Justice Crane correctly determined that this lease requires a change to the 80-20 rule. The thing that...
Why does it require a change? I mean, I'm looking at that line. It says if the statute, it doesn't say changes it, it says if it permits a greater or lesser percentage of gross income to be derived from the non-tenant stockholders. And it does allow that to happen if they can fit into the other categories, and so they can still, the tenants can still maintain the residential tax benefit, then you can get more from the commercial tenants because they don't have to fit into that particular one. So doesn't that allow them, because there's now other options?
Respectfully, Justice Kapnick, the answer is no.
Why not?
The lease says specifically, and this is a problem with the appellant's entire appeal, is that they consistently leave off the last phrase of this paragraph 2 of the lease. They consistently, throughout both of their briefs, stop reading this lease at the word deemed modified. Okay, this is the first reason. It's not just that it's deemed modified. It's deemed modified to what? To a percentage equal to the maximum percentage of gross income from non-tenant stockholders permitted under said statute. That we need to have the new percentages set by Congress in order to know what the new rent is. Now, Telemann says that it's optional. Below, they said the 80-20 rule was eliminated. But as you heard today, and as they conceded below, they concede that the 80-20 rule is exactly the same in its percentages now as it was when this lease was entered into. As Justice Renwick pointed out, if the parties wanted to have a more capacious, as the appellant says, broadly worded lease, they could have. This is not a spacey, roomy lease. These terms are extremely specific. Justice Crane was incredibly correct when she said there's a specific formula here and it has to be followed. Under their new theory that the 80-20 rule is now optional, which it is still there, and under this term of this specific lease provision, we need Congress to amend the percentages of the 80-20 rule in order to fit into the specific formula that these parties agreed to. There's just no way to say that because now the 80-20 rule is optional, as they say, they get to decide what the new rent will be. It leaves the new rent entirely in their hands. They haven't, by the way, they're saying that there's no dispute in the record that they met the 90% rule. With all due respect to my colleague, that's absolutely not the case, and the record doesn't support it. There was one paragraph in the amended complaint and one paragraph in their affirmation that they submitted in support of their cross motion for summary judgment that says totally conclusively that we met the 90% requirements in the past and will continue to meet it for the rest of the lease's term. That we contested in our counterstatement of material facts that they even established that they met the 90% rule, but I don't want to get bogged down in those weeds. I think it's more important that the court understand that it absolutely was not optional. And my colleague said that the 80-20 rule is irrelevant, and it is absolutely not irrelevant. It's highly relevant because of the last phrase of this paragraph 2 of the lease, in addition to the fact that it's also relevant for in the event that phrase. But the second part is we have to have a new percentage of gross income. It didn't say cash requirements, as my colleague quoted or tried to quote from the lease. The lease specifically says, then 20% shall be deemed modified to be a percentage equal to the maximum percentage of gross income, not cash requirements, from a non-tenant stockholder permitted under said statute. Said statute at the time the lease was written was IRC 216B1D. That was only the 80-20 rule. That's what the parties were talking about. That's exactly what the parties were talking about. We can't look outside this lease. They've conceded finally that it's not an ambiguous lease. And we just then, under New York law, look at the particular precise terms of this lease, which has a precise formula, as Justice Crane concluded. I'd like to make a few more points if I have some time.
You have about 30 seconds.
Okay. Crucially, the fact that, I think I said it, but I just want to reiterate it, they conceded below that the 80-20 rule percentages were not changed. They conceded that the 80-20 rule percentages are still there. Congress was specific in the House Ways and Means Committee notes that it was just adding 2 non-income-based tests to permit co-ops to maintain the tax deduction. It was not removing the 80-20 rule at all.
What about Congress's statement of its intent, being conscious of the fact that the way it was written was causing the landlords to have to charge very under-market rents?
Thank you, Justice Kavanaugh, for that question. There may be other co-ops in the city that can now have new leases with new rent terms, but our lease that we're looking at does not allow us to do that. It simply does not. I just wanted to say in conclusion that this is not a broadly worded, open-ended lease provision, that Teleman's requests would amount to a complete rewriting of this lease and would render this lease a nullity. They play fast and loose with the language of the lease instead of looking to the precise language.
Thank you.
Justice Crane was not convinced, was not persuaded that she had any ability to revise, interpret, or change the unambiguous terms of the lease, and I respectfully say that this court should not be either. Thank you.
Thank you.
Far from playing fast and loose with the terms of the lease, all we want the court to do is read the words. It says that if the new successor statute permits a different amount of gross income to be derived from non-tenant shareholders, then the lease, the rent term shall be deemed modified. It does not say if the successor statute changes the 80-20 numbers, if it changes the 80-20 formula. No, it says a successor statute, any successor statute that permits a different amount. This one does by rendering the 80-20 rule legally irrelevant. Now, opposing counsel says it's actually disputed that we meet one of the other criteria. No, it's not. It was asserted in the moving affidavit of Danny Golden in paragraph 12 that Telemann meets the 90% expenditure rule, and in response, VCW said in paragraph 16 of their, at SR 12 of the supplemental record, that they are in no position to dispute that. And under summary judgment law in this court, I'm referring now to cases like Zuckerman versus City of New York, 49 New York 2nd, 557 to 562. You cannot defeat summary judgment without coming forward with some evidentiary proof of your own. They asserted in their response that they had none. Nor is it true, as opposing counsel just said, that we somehow have boundless discretion over what the rent will be. The rent, again, is set by the plain language of the rent provision, which says that the rent shall be changed to the same percentage that is the maximum of gross income permitted by the lease. That is 100% by the simple rules of arithmetic, and it therefore becomes 100% of cash requirements. And I'll make one last point. This is the manifest intent of the parties to this lease. The parties incorporated the congressional statute. They anticipated that Congress might change the law. Congress changed the law precisely for cases like this one. They saw that market rents were being, rents were being artificially depressed by the 80-20 rule, and they made the 80-20 rule optional. And this case was the poster child. Because while they have been under the benefit and the umbrella of the 80-20 rule for some 5 years in a row, they paid a total of $267,000 in rent to Telamon, while at the same time charging their sublessee $7.7 million. When the rent is revised as it should be, when the Supreme Court decision is overturned, hopefully by this court, they will still be paying less than market rent, but the amount of that windfall that they used to have under what is now the optional 80-20 rule will at least be a little less gigantic than it's been for the last 5 years, when they've gone essentially into the landlord business themselves.
Thank you.
Thank you, Your Honor.
Thank you both. Kim versus NRT and why?
Good afternoon, Justices. May it please the Court, my name is Do Lee, and I represent the appellant plaintiff, Dae-Hoon Kim. The crux of this appeal is that both the first complaint in 2013 and the arbitration award in 2015, as well as the letter agreement in 2010, were based on plaintiff's knowledge at that time of the units that the defendants allegedly collected commissions on that he was not paid on.
Can I just stop you there and just ask, this case went to arbitration, and the allegations that were in the Kings County complaint were comprehended within the scope of the arbitration.
The first complaint was.
And the Kings County complaint, I think, listed 5 different claims. And they went before the arbitrator, and the arbitrator decided that. And then nobody went back. I think there was a clause in the settlement of the Kings County document that they could go back and refile within 3 months or so. No one did that. My question is, why doesn't the arbitration stand here, and why isn't that final?
Well, there's one key, that's an important question, Justice. There's one key point upon close inspection of the record. The subsequent complaint in 2019 lists 24 units in that complaint which were not covered in the first complaint, and therefore also not covered by the 2015 arbitration. I have a list of them if you want them, but if you compare the two complaints, there are 24, I counted, units which are not covered. So those, obviously, I mean, I have the case law. If the issue wasn't actually litigated as to those 24 units, then those would not be precluded by either the first action, the letter complaint, or the arbitration award. Furthermore, the facts pled in the underlying case at bar, while it doesn't explicitly plead an action for fraudulent concealment and contract, essentially the facts, he's saying that they fraudulently concealed something in the contract detrimental to my contractual right. So because of that,
But what was the date of that contract? Don't you have a statute of limitations problem on that claim?
That's exactly what I'm addressing, Justice.
Okay.
So yes, so the contract was initially in 2008. The fee period concluded in 2009. However, like case law says, for instance, in Re Carlton versus Zoning Board of Appeals, Town of Bedford, 11182nd, 169, or Winder versus MK, and Roman numerals MKVII, Westchester LLC, 29280, second 597. Basically, matters apparent on the face of the record. Oh, I'm sorry, I'm citing the wrong case. Basically, that if there is a fraud, CPLR 213.8 tells us that the statute of limitations would run 2 years from when diligent investigation would have revealed the fraud. In this case, the facts that are being pled is a fraudulent concealment in contract. The facts and the timeline indicate that there were units between the 2013 complaint and the 2019 complaint that were not revealed until the subsequent 2019 complaint. That's a tribal issue of fact as to whether a diligent search, whether my client should have discovered them earlier, whether he did a diligent search and it was reasonable that he discovered them later on, closer to 2019, because in that case, he would have 2 years after the discovery or when a diligent search would have indicated those units.
Well, are you saying on each apartment it was 2 years from each, that each was its own fraudulent concealment?
Yes, absolutely, Justice. If the commission agreement said that my client got X amount, X percentage per unit pursuant to the access and the fee periods, then yes, each unit that was concealed would be a distinct and separate wrong. So it wouldn't be covered by an earlier action if that unit wasn't actually, whether the wrong of concealing that unit was actually litigated. And so basically, because that 2015 arbitration didn't cover these 24 units, the wrongs alleged for those 24 units weren't actually fully litigated either in the first action or in the subsequent arbitration, and definitely weren't covered in the 2010 letter agreement that's also cited. That's it, Your Honors. If you don't have any questions, then I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court. Mark Singer from Orloff, Lowenbeck, Stifelman, and Siegel on behalf of the respondents. This action is a classic case for the application of res judicata and collateral estoppel, and that's precisely what the lower court Justice Love found. We have a case that dates back to 2010 and a series of actions that were filed over and over and over again.
Well, you know, just skipping to the point,
Yes.
you know, I think we know that what the history of it. So my question is, counsel just raised the possibility, the claim that several of the apartments that were sold were apartments he did not know about until more recently, and so that they were not be controlled, and that there's an issue of fact about that. Now, I don't know, did the I'd like you to respond to that, and also, there was a second agreement, I don't know if that was the referral director agreement or whatever, where you said, look, we'll give you 10% on this, and you can get this, and that's the end of the deal. And was that the end of the deal? It doesn't matter if he came up with more apartments.
Yes, Your Honor. The two responses. One is the same parties, the same agreements, the same claims are all what was adjudicated 6, 7 years ago. So claim preclusion and issue preclusion, res judicata, collateral estoppel, that bars any claims, whether they're discovered today.
But I don't think you're answering my colleague's question,
Sorry.
which I'm interested in too. Your adversary said that there were additional transactions following the arbitration. So were there, weren't there? How do those figure into it? Are they part of the agreement, or are they precluded by the agreement that only these apartments are subject to 10% now, the resettlement of the 2008 agreement? I'm just not following.
Yes, Your Honor. So the answer is they are precluded. They're precluded by the July 28, 2010 agreement, which both the arbitration award as well as the lower court, Justice Love, determined is a valid.
Did they take place after the arbitration? Did the transactions take place after? This is a factual question.
The sales of these units may have taken place after the arbitration. However, the agreements with which they are seeking to recover were already adjudicated and already determined back in 2015 under the arbitration. And the arbitration conclusively determined that the July 28, 2010 agreement was binding, issued an award.
That they relinquished any future claims.
And they had no future claims, correct, beyond that. Any claim as to that agreement, whether it was fraudulently induced or anything of that sort, has already been barred by the statute of limitations, because and as the lower court correctly determined, that any claim for rescission of that agreement had to be brought within 6 years of the agreement, which would have put it into 2016, or alternatively within 2 years of discovery of that fraud, which would have existed at the time of the first claim that was filed back in 2013, which raised issues pertaining to that agreement. And then the parties stipulated and agreed to go to arbitration, and arbitration conclusively determined that that agreement was binding and issued an award which was in fact paid. End of story. 2015 is where this ended. 5 years later, there's a filing of a new claim asserting essentially the same claims over again.
So even if there were allegedly subsequent transactions that occurred after the arbitration, the July 28, 2010 letter, which we're talking about, which was that extended some of the time, said if you take this 10% referral, you will have no further referral fee claims to Charles Atias at the Corcoran Group except for these apartments. So that was the end of that.
Absolutely correct, Your Honor. 100%.
Thank you.
Thank you, Your Honors.
So, counsel answered a question saying that basically after the fee period was over, that he wasn't sure whether there were any transactions after that time period, after the 2010 agreement. 2 points to that. First of all, I submit that the 2010 agreement, I submit that the defendant respondents are treating that as a general release for all future claims. And it is not unambiguously a general release on all future claims, and especially not a release on any possible fraud or concealment or any other claim.
But you don't have a claim for fraud here, do you?
Well,
Do you?
the language of the pleadings support an action for fraud. Like I
The
said,
simple answer is you don't.
I'm sorry?
The simple answer is that you do not have such a claim.
No, but I've pled sufficient facts in order to support that claim, Your Honor. And the case law says if it's apparent on the face of the record, that it can be considered on appeal.
I think fraud has to be claimed with specificity, but okay, yeah, that's the way I understand it.
Well, the specificity would be that there were commissions that my client was due that the defendants did not reveal or pay upon, which
Yeah.
is alleged.
Well, that's not those aren't allegations of fraud.
Well,
That is, I don't know what it is. Maybe it's non-compliance with the agreement, but I don't know
I
what
believe,
what that makes that as fraud.
I believe the specific cause of action, if I'm not mistaken, is fraudulent concealment in contract.
Thank you.
Thank you.
Thank you both. People versus Colin Washington.
Good afternoon. Simon Greenberg for Appellant Colin Washington. Mr. Washington's aggregate sentence of 2 to 6 years was excessive because of mitigating circumstances for his violation of the no arrest condition in his plea agreement with the court. Because although he did not complete a treatment program after his plea, he did attend treatment for much of the period between the plea and sentence, and the court did not actually find him to be in violation of that condition. The court recognized that he did a substantial amount of treatment and made progress with his drug addiction. And also, at sentencing, he expressed sincere remorse, and although he does have a lengthy criminal history, the vast majority of his prior convictions were for nonviolent offenses relating to his drug addiction. And I also wanted to specifically address the fact that he's currently on parole, because his parole sentence, if he's required to serve it until the maximum, will end up spanning more than 4.5 years. And as we argued in our reply brief, that is way more than is necessary to guard against reoffending. The research that we cited in our brief from the Columbia University Justice Lab demonstrates that the vast majority of reoffenses, that's new crimes, occur within the first 2 years of parole, and Mr. Washington has now been on parole for over 2.5 years, and his parole is still going to have to last another 2 years for if his sentence is not decreased in the interest of justice.
He only served like 1 year and 2 months, actually, of his sentence. Is that correct?
He served. I believe he served. I believe he, because of time he spent in jail before he pled guilty, and combined with time that he spent in prison, he served 1.5 years incarcerated, because he actually got out before the 2-year mark.
Right.
Because he was released at his merit time release date, which allows you to actually be released 6 months in advance of your earliest release date if you just go by the parole eligibility date. And so that's why I'm saying that if he has to serve his parole until the maximum expiration date, he'll end up serving about 4.5 years of parole. And we also, in our reply brief, cited the opinions of 3 district attorneys within New York City about the extensively documented problems with the parole system, how it results in technical parole violations that send people back to prison at a disproportionate rate for black people, like Mr. Washington. And so because 4.5 years of parole, in effect 4.5 years of parole is way more than is necessary and can be also very counterproductive, we would ask the court to reduce Mr. Washington's sentence in the interest of justice so that he ends up serving less parole than he's currently going to be required to serve. And if your honors don't have any...
I understand your arguments generally about parole, but is there anything about this defendant, Mr. Washington in particular, which would make him an argument to be made specifically about him that would indicate that parole is especially not right for him?
I think that there's nothing that distinguishes him specifically to establish that 4.5 years of parole is excessive specifically just for him, but the research that we cited in our reply brief talks about an acknowledgement from various district attorney's office that...
Right, I'm aware
yeah.
of that research and the statements.
Yes, Your Honor.
As to the parole system generally. Right.
Sure. I don't think that we're relying...
I was going to say, not everybody's released before the minimum period of time of incarceration, are they?
Not everybody, because...
That depends on your behavior.
It does.
When you're in prison, doesn't it?
In fact, so, I mean, not everybody's
he's been out for 2.5 years, so we can't attribute that to COVID. We have to attribute it to him and his good behavior, isn't that right?
I think that the getting out of prison was certainly a result of his good behavior and his compliance with his programming requirements, because he got out in January of 2019.
And he's been on parole for 2.5 years.
That's correct, Your Honor.
Without rearrest?
He has been arrested since he's been on parole. I do want, I have to be honest about that, Your Honor. He was...
You should be.
Yeah.
That's always best.
Yes. He was convicted for possessing crack only in March 2019 after he got out on parole in January of 2019. And then he also did have a conviction for shoplifting in August of 2019, which was over 2 years ago. And currently he's working a job as a construction site safety manager, which required him to get a license. And so that's at a company called Hakeem Maintenance Services. And so he is gainfully employed currently, and he's also living with his wife and his son. They're currently in a homeless shelter, but they did receive a voucher recently, and they're looking to be able to move into an apartment. So that's his really how his life is going currently.
Thank you.
Thank you, Your Honor.
May it please the court, Claire Lynch for the people. Your Honor, defendant's sentence here was entirely fair and appropriate and should not be reduced on appeal. Justice Dwyer gave defendant multiple chances.
Well, he's on parole, right? And he's been on parole for a while.
Yes.
Right? And not doing terribly, certainly making some strides since 2019.
Yes, Your Honor.
And there has been discussion, discussion is not the right word, but perhaps by district attorneys about the parole system and the need to improve it.
Yes.
I don't even, maybe even the district attorney who runs your office may have made those statements.
Yes, however, I think that the facts of each case need to be considered on appeal, and in this case, parole should not be reduced. It was part of the sentence that was carefully considered by Justice Dwyer, who had, originally offered defendant a conditional
That was
release.
in, what year was that?
That was 2017.
2017, a little before these discussions about parole were made by some of the district attorneys and before they were really thinking more about this issue.
However, I think that, defendant's sentence here was still in the low end of the range that he could have received. Justice Dwyer did inform defendant very clearly that if he did violate any of those plea conditions, he could be sentenced up to 11 years. And here it was 2 to 6, and he's out on parole, and the supervision that he's receiving on parole will benefit him in the long run. So again, Justice Dwyer gave him multiple chances, and the interest of justice would not be served by reducing this sentence. So unless there are any further questions,
Thank you.
we affirm. Thank you.
I have a very brief rebuttal, Your Honors. We disagree with my adversary's description of the ultimate sentence that Mr. Washington received as being in the low end of the range. He received 2 to 6. As my adversary just said, the maximum he could have gotten was an indeterminate where the maximum was 11. So that's actually more than half of the maximum prison sentence. So
What was the minimum?
the minimum prison, well, he actually, based on the promise, the conditional promise that he originally received, he could have gotten no prison time at all. He could have gotten a conditional
Yeah,
discharge.
I know, but that didn't work out. So-
Right. The
so
minimum
then-
prison, the minimum indeterminate prison sentence would be 1 to 3 on both counts. He got 1 to 3 on the E, and he got
Right.
2 to
Right,
6
so-
on the D.
So what are you asking for now? What do you want us to do?
Terminate his
We would like, Your Honors, to reduce his sentence in such a way that effectively terminates his parole. And so
Well, would reducing it to the minimum do that?
it would do that. And also, I mean, reducing it to the minimum certainly would terminate his parole. I believe that reducing the 2 to 6 to 1 1/3 to 4 would also terminate his parole. But obviously, I think to be safe, if I'm going to argue that we'd like you to terminate his parole, we would prefer that you reduce it to the minimum prison sentence. So if Your Honors have no further questions, I'd rest at this time.
Thank you. Thank you both. People versus Keith Little.
Good afternoon, Your Honors.
Good
Ronald Zapata with legal aid for appellant Keith Little. The lower court should have granted a Wade hearing when the prosecution failed to satisfy its burden to show that the police officer's identification of appellant was confirmatory as a matter of law. The prosecution relied on the voluntary disclosure form and an affirmation in opposition to the Wade hearing to meet its burden, but neither document provided any facts showing that the identification could not have been mistaken or even that it was part of a police operation.
Counsel, can I ask you a question? Even if we were to think that there should have been a Wade hearing, there was a Huntley Map Dunaway hearing, which I agree, was not a Wade hearing. The judge specifically said it wasn't. What else could come out at the Wade hearing that didn't already come out at the omnibus hearing that was held that might help your client?
Sure, Your Honor. Well, well, what didn't come out at the hearing, and first of all, obviously, because it wasn't a Wade hearing, the defense counsel wasn't prepared to reach Wade issues, and therefore didn't ask certain questions that he could have. Some of the facts that it could have been elicited included in terms of the viewing of the suspect, like how long they viewed them. There are more meticulous details about if they saw the suspect's face.
But this was the description given by, we're talking about a police officer who viewed him, right?
Yes.
And the police officer viewed him and then relayed with sufficient detail so that they could stop him, relayed the description to him, to the other police officers. And then the same police officer who saw him and described him to the other police officers confirmed and said, that's the guy, when they had him. I mean, he was the very person who gave the description of the person in the first place, wasn't he?
Yes.
So
But
I'm a little bit confused about what else he would have need to have added to the description he gave that led them, people who didn't know who he was talking about, who had never seen him, led them to be able to stop him.
Well, it's about the quality of the viewing of the suspect, and then once you don't have this the warrant exception to apply, there has to be a Wade decision, and no Wade decision was ever made here. The only thing this court has
There wasn't a Wade hearing. I
Yes.
get that.
Yes.
But, okay, so in the omnibus motion, there was a request for a Wade hearing.
Yes.
That was denied.
Yes.
The court decided to give this Huntley map Dunaway.
Yes.
At the beginning of the Huntley map Dunaway, did anybody say, I just want to renew my objection to the Wade. I want a Wade. Let's add a Wade to this.
At the end of the hearing,
No, at the beginning of the hearing, because that's when you would ask to join the thing to put the Wade. I mean, why would you want to come back another day?
Well,
Say, I want to add the Wade hearing. I want this also to be. Nobody said that.
No, not at the beginning. But the defense counsel.
It was after, I think it was the people the detective who opened the door, if you will, made some statements about the description and everything else, that then the defense attorney, hearing that they put their foot in it, jumped up and said, I want to Wade, rightfully so.
Well, actually, defense counsel asked to reopen for a Wade decision.
After those statements.
No, it was before the prosecutor's statement, actually. Defense counsel asked first, saying, hey, after the hearing, hey, this evidence came out.
But it was after the testimony of the officer who.
Yes,
yeah.
Exactly. Well, what defense counsel was saying there was, okay, additional evidence came out in the suppression hearing, and it showed that this was not confirmatory, and therefore a Wade hearing was required on a reopened motion. And even the prosecutor below at the hearing said, hey, the Court of Appeals just decided People v. Paquette. And in that case, they had very similar facts where the officer who initially viewed the suspect from across the street, and the Court of Appeals in Paquette said, hey, that's not enough to meet the Wharton exception, and therefore a Wade hearing should have been held. So even the prosecutor agreed with defense counsel that a Wade hearing and decision should have been made.
I'm not saying that a Wade hearing shouldn't have been given. What I think the question from my colleague was, what else would be gleaned from a Wade hearing that was not already established with regard to the ID? There's an ID. The question is whether the defendant was the person who was ID'd originally by the police officer. That's all I'm asking. What other information?
For instance, defense counsel asked in support of a Wade decision for additional discovery regarding the police communications in terms of the viewing officers' contacts with other officers during this situation to be able to then pinpoint the time periods between the viewing.
What was the description that was given by the officer of the defendant?
I believe that they gave a clothing description and mentioned that it was.
What exactly was it? It's okay, I don't want to waste time.
Yeah, sorry.
One more question.
Yeah.
You'll
Go ahead.
allow it, yeah. At one point during the Matt Dunaway hearing, or let me rephrase it, did the defense attorney have an opportunity to cross-examine the officer about his testimony concerning the confirmatory ID?
He had the opportunity, but because it wasn't for a Wade hearing, it wouldn't have been his focus. And obviously, the court could have also disallowed any questioning because it would have been for Wade purposes, which is not the purpose of the hearing.
So he cross-examined the attorney, but he didn't cross-examine him, or he...
Cross-examine the police officer, you mean?
Yes, I didn't, right. The police officer, thank you.
Sure.
It's been a long afternoon, right? So he got to question the police officer, cross-examine him, but not specifically on the issues regarding Wade, because there was no Wade hearing. It wasn't a Wade hearing.
Yeah, it wasn't a Wade hearing.
Yeah.
So because there was no Wade decision, any of these questions regarding if enough facts would have been harmless, there's no harmless error
With the
decision
Wade,
to be made
yeah.
here because there was no decision. Unless there are any other questions, I'm back.
Okay.
Yeah.
May it please the court, Amanda Regan on behalf of the people. I'd like to just pick up where we just left off.
Well, I'd like you to start somewhere else, and I'd like to find out what the description was that the officer gave to his brethren officers who made the stop.
Sure. This was a very specific description. He described the defendant as being a black man who was heavyset, approximately 300 pounds, and that he was wearing a maroon jacket, a Yankees baseball hat, and carrying a small laptop bag. And of course, when the fellow officer...
Male, black, 300 pounds, what?
Maroon jacket.
Maroon jacket.
Yankees baseball cap, blue Yankees baseball cap, and a black small laptop bag. And of course, when the fellow officer apprehended the defendant, he matched that description exactly, which was why the fellow officer stopped him. But just briefly to address what was just discussed by my adversary, respectfully, I think that he is being slightly disingenuous with the record in saying that defense counsel did not have the opportunity to ask quote-unquote Wade-type questions at the hearing on other issues. I point the courts to pages 37 through 41 and 62 through 63 of the record, where the defense counsel actually did ask Wade-type questions. How far were you from the defendant when you first observed him? How could you see, what he was doing and things
Well,
of
there's
that
a difference
nature.
between asking Wade-type questions and having a Wade hearing where you get the full breadth of questioning.
Absolutely, but the opportunity was there, and the defense counsel below did take the opportunity to ask those sorts of questions.
Well, he got to ask a few questions, but was stopped by the court, who said it's not a Wade hearing, I guess.
That was at the end. That the court did not preclude his cross-examination at all. That was at the end of the hearing, at the end of all of the evidence, when defense
When he
counsel
asked for a full Wade hearing.
Exactly, and as Your Honor pointed out, he did not make that request at the beginning of the hearing. And to touch briefly on preservation, defendant's current claims are only partially preserved, and I point this court to its decision in Houston, which we cite on page 8, and I think again on page 12 of our brief, which says that simply because a defendant requests a Wade hearing, he does not preserve his arguments that the people failed to provide the lower court with enough information upon which to conclude that a Wade hearing was confirmatory, and that's exactly the situation we have here.
You mean from the omnibus, when the court saw the omnibus and
Yes.
made that decision, it was making the decision based on the absence of not the absence of information, but the information of the ID and that the person who was arrested was the same with regard to all details.
Exactly, yes. And of course here, the judge below made its decision based on the VDF and the people's affirmation, but if the court was not limited to just looking at those documents. And we submit that had the judge not looked at the felony complaint, that would have been improper. It's part of the record that's before the judge. So of course the judge took that into consideration as well. And with regards to the grand jury minutes, I think our argument is misconstrued a bit by my adversary. We're not saying that the court needed to review those minutes. We're simply saying that the court did in fact review those minutes at the defendant's request. And that was just either additional evidence before the court that supported its summary denial of the Wade prong of the omnibus motion. So unless your honors have any other questions, we would ask that you affirm.
Thank you.
First, regarding the prosecution's arguments that it should consider documents that it did not present as part of its burden for the omnibus decision, those arguments are unpreserved. The prosecution only cited to the voluntary disclosure form in its opposing affirmation, and therefore this court cannot reach that decision. The court is also prohibited from considering any arguments that were not ruled upon by the trial court, and the trial court here specifically stated that it only considered a voluntary disclosure form and the affirmation in the omnibus decision. And under CPL 470.15.1, as well as the Court of Appeals decisions and LaFontaine and such, this court cannot decide an argument that was not ruled upon by the trial court.
Let me just ask you, when the court got the omnibus motion and the Wade hearing was requested, and the other issues were also requested, rather other hearings were also requested, the court made a decision based on that a Wade hearing was not necessary. Now, where the court feels that there is enough information in the omnibus motion or whatever it is that's presented to the court that does not raise sufficient facts to warrant a hearing, the court can summarily deny that hearing, can deny it right there. Isn't that what happened here? Isn't that why there was no Wade? And then what happened at the Map Dunaway hearing was that the court figured, okay, we're in the hearing, go ahead, ask some questions, gave more leeway, gave leeway into allowing counsel to ask these Wade-type questions. And so then, after that, defense attorney, being a good defense attorney, said, well, now I want a Wade hearing. But the court had denied the Wade hearing because there was no basis to grant a Wade hearing, in the court's opinion, based on the description being the same. What changed? Nothing came out in those questions that changed.
Yes, and so I think the way the analysis has to work is first you have to decide if the omnibus decision was correct based on what the prosecution provided, because it's their burden to prove that a Wharton exception applies to granting a Wade hearing. And so they only provided the voluntary disclosure form and their opposition affirmation. And they provided absolutely no facts to show that this identification was somehow confirmatory. And the only way for something to be confirmatory as a matter of law is if basically there's no way that the identification could have been mistaken. And I think one...
And I guess based on the description that was transmitted to the fellow officers and the description and the condition of the defendant at the time of arrest, the court said exact same.
But that would be a Wade decision. That's a problem. I think.
I beg your pardon?
That would be a Wade decision in terms of, okay,
But that's the decision that the judge made prior thereto that made the judge decide not to grant Wade. That was information that the judge had from the omnibus.
No, but that wasn't the facts that the court decided on. The court explicitly stated, I decided this on a voluntary disclosure form, and the opposing affirmation. None of the facts that came out from the hearing were in those documents. And
No, not that came out from the hearing. At the VDF and the other, what did you say there was?
the opposing affirmation to the
The
omnibus
opposing
motion.
affirmation, did it not say that this was a 300-pound man?
No, it did
with
not.
a maroon jacket?
No.
And a baseball cap? None of that was in
None
there?
of that. None. Absolutely not.
No description at all?
The only thing it said in conclusory terms, this is a confirmatory identification, and this is part of the arrest process, the identification. And under the Court of Appeals decisions, that's just simply not enough. And can I just make one more quick point? I know my time's up, but I just wanted to really note that the Wharton exception was never intended to apply to in circumstances such as this. Wharton only applies to a planned police operation, so like a buy and bust, where the officers are planned and in positions to make such a viewing that there's no way that there could be a mistake. What happened here is, according to the, even if you consider the hearing evidence, because there's no evidence presented in documents that were provided against the omnibus decision regarding the Wade hearing.
And just one more clarification, that information about the description came out at the Wade-Huntley?
Yes.
Dunaway?
Yes.
Okay.
It never came out in any of the documents
Okay,
that were
all right.
provided, for the omnibus decision.
But
And
you were finishing, you were saying something.
Yes, and so Wharton only applies to planned police operations, and what happened here, even if you consider the hearing evidence, is this police officer was not part of some planned police operation. He was eating lunch in his car, and just like any other
Well,
layperson.
that may not be typically how it is applied, but had that information come out before, perhaps.
With
The
all
same
due respect,
identification is the same identification.
with all due respect, like the Wharton exception is only about planned police operations. If the police witness is acting the same way as a lay witness, the Court of Appeals, as explicitly stated, police identifications do not enjoy any exception to the hearing requirement for an identification, and therefore, if a lay witness was in the same situation here, the exception would not apply, and just because this is a police officer, the exception shouldn't apply here as well.
Thank you.
Thank you.
Thank you both.
Eric, you can go. I got it. Yeah. No, I know you counting that half out.